Okay, it looks like we now have a quorum and we'll begin the meeting. This meeting is being recorded. And with permission of the chair, I will start with roll call. Dina Roche.
Here.
Ken Bacon.
Here.
Sarah Bonola. Steve Bundy.
Here.
David Carr.
Here.
Justin Fields.
Here.
Toby Inlander. Adam Koss.
Here.
Brendan Kruger.
Here.
Amber Lee. Amber, I see you, but I can't hear you.
Let me log back in.
Oh, there you are.
No, we can hear
Okay.
you now.
Okay, Joel Mark,
Here.
Kyla Rowe,
Here.
Hunter Starr.
Mimi, it looks like both Hunter and Sarah are in the attendees list. And so
Okay,
it looks
one
like they're
second.
here if we could move them over.
Will do. Also, Andrew, I made you a co-host, so you can do that at any time as well.
Okay, cool. Thanks.
I am here.
Thank you. And okay, we are good.
Great. So why don't we go ahead and get started? We've taken a roll call and it's an opportunity to ask if there's any public comment. I don't know if anyone indicated to Mimi if there was public comment.
Yes, if there's any members of the public who would like to give public comment, please use the raise hand function to indicate that. Seeing none, I think we can continue.
Okay, great. Why don't we have announcements and the staff report?
Okay, great. I will try to be brief, but there are a few important things I want to touch upon. As you saw in the message preparing for this meeting, there's a lot to get to today, and a lot of several items will take careful thought and deliberation. So I don't want to take too much time. So with that throat clearing, I'll quickly report at the May 13th RAD meeting. The duties to prospective client opinion was approved and is on the State Bar's website. It is now formal opinion number 2021-205. And the colleague impairment opinion was also approved and is on the State Bar's website. And that is formal opinion number 2021-206. And at that meeting as well, the arbitration advisory regarding disputes over costs and expenses was also approved. It is on the mandatory fee arbitration pages of the State Bar's website, which has a arbitration advisory link, and that opinion resides there as arbitration advisory number 2021-01. We're also conducting a fee arbitrator training on Tuesday, June 15th. I know this is really short notice, but like the symposium, we had been limited to 500 participants, and this training was included in an all licensee State Bar email. And as a result, we hit our max really quickly. I think a lot of people signed up either because hopefully they're interested in being volunteers for the arbitration program, or that they saw 2.75 hours of free CLE credit and they took advantage of that. The reason why I'm sharing it with you all is because I know we have a few folks here who are well-trained and have acted as arbitrators in fee disputes, but I'm certain several of you have not. And because we're now tasked with drafting arbitration advisories, this would be a great opportunity. It's from 1 to 4 on Tuesday the 15th. It's free for you all if you're interested to attend. And it'll be a great way to get a good sense of what's part of the fee arbitration process. If you are interested, please email myself and Mimi. I'm actually on the eastern shores of the Chesapeake Bay right now, heading to a in-law cousin's wedding. So I'll have to leave this meeting early today, probably around the lunch break. But if you send an email to myself or Mimi, we'll get you the registration link, and would encourage you to sign up as soon as possible, either end of the day today or by Monday morning. And you can attend that Zoom training. You also, I'm sure no one here needs CLE credit. You do get 1 hour of ethics, and you get 2.75 hours of CLE if you attend the whole thing. And another personal pitch, if you attend the training and you're interested in becoming an arbitrator, there will be an application to apply to be a volunteer arbitrator for the State Bar's mandatory fee arbitration program. We are always looking for excellent, thoughtful, judicious-minded individuals who could serve as arbitrators, and I'm confident all of you would be excellent in that. So my long-winded pitch, but I do think it would be really helpful for those of you who could attend to give a good foundation in arbitration to attend that training. Are there any questions about that before I transition to the letter that leadership has drafted? No pressure, but I know that was a lot of information. So if anyone has questions, I would prefer to talk about that now before I move on. Okay, cool. So if you're interested, just shoot me and Mimi an email and we'll get you that registration link. It would be great if as many of you who are interested as possible could attend. Okay, so last and importantly is leadership included in the email where I set forth the agenda for today as indicated by Dina, and late meeting materials was attached a memorandum which reflects a letter that's been drafted by the committee leadership, and they can describe in more detail after I introduce it to you all if they would like, but they would like to submit this letter to the Board of Trustees, but before doing that, I think it would be prudent and helpful, if not persuasive, if the committee were to take formal action to endorse the letter by receiving a motion, a second, and voting that this letter be submitted on behalf of the committee. And this would go to the board as part of this year's appointment process, and it's a request to reinstate the advisor position. And just that by way of background, the committee had always had an advisor position. The advisor is typically the immediate preceding year's chairperson. However, in 2017, the State Bar went through, as they transitioned from associational bar association to strictly a regulatory organization, they looked at all their committees and commissions, and they had a governance in the public interest task force report, which had several appendices, and what became globally known as Appendix I was how to deal with all the committees and commissions of the State Bar. Not how to deal with them, but things to address about existing committees and commissions of the State Bar. And one of the global recommendations about committees and commissions was to remove the advisor position from all committees and commissions. So COPRAC was not singled out, but the recommendation was to remove committees and commissions from, remove advisors from committees and commissions of the State Bar. And we've gone 1 year without an advisor, and then last year we had this past year we've had a tremendous year with an advisor, Steve Bundy, and so I think leadership was in a position to say they've had experience with and without the advisor, and in addition to other reasons, they would like to request that the advisor position be reinstated. And so with that introduction, I leave it to everyone else to describe what other aspects of the letter and memo they want to highlight.
Can everybody hear me? Oh,
Yes.
Good. I was having some audio problems earlier. Andrew, would it be appropriate to make a motion to tee off the discussion? I'll say I saw nothing in the letter that I thought needed changing, and I thought it was very good. So if it's appropriate, I'll make a motion to send it to the board, and I guess we can debate that.
I just
I'll
had,
second that motion.
Oh, we'll see. My audio wasn't working.
No, I didn't hear you, David.
Okay.
I had one nit to make on it. I think it's a great letter. On the second page, where it talks about the tasks of the fee arbitration committee, we have assumed the tasks. I would just take out the, because we haven't assumed all of them. And maybe I'm still a little bitter that they got rid of the fee arbitration committee, but between staff and myself as presiding arbitrator, we all have a lot more work we have to do now that COPRAC doesn't do, rule revisions and things of that nature. So just a small nit, but that was my only comment. I would just
So
say,
to take out in the second paragraph, the in front of
Yeah.
tasks.
yes, we have assumed tasks, not all of them.
I also had just one small nit. Under the COPRAC membership changes and advisor role, that paragraph, there's somewhere where it says, I think it should be nature of COPRAC's work instead of the COPRAC's work. Kind of midway through that paragraph, the unique nature. And I just had one quick question. We say about, though they could have treated it as a victory lap. Is that some concern we're reacting to? I was just wondering.
I had that same concern.
Because I kind of think it might be better to just phrase it as they've typically continued to participate vigorously, or just focus on that, unless there's a concern been raised that someone would treat it as a victory lap, which seems kind of unusual. I wouldn't perceive that, but maybe it's some perception that we want to address, and that's fine with me. I just wanted to raise it.
That's a good catch, Sarah. I don't want to speak for Steve, Dina, or Justin. I'll just speak from staff's perspective. I think part of the governance and the public interest task force report with respect to advisors on committees, one of the concerns was this wasn't true with COPRAC, but and I don't know, I'm not familiar with the other committees that they may have been speaking about. But I believe in the report, it references that some committees or commissions would keep on ad hoc or ex officio members indefinitely, or the committee would allow them to come to meetings and observe and maybe participate without the oversight and appointment of the board. And so that was one of the policy reasons why the board eliminated advisors for all committees and commissions. And so, while not directly, I think that this phrase is getting a little bit to that. You know, the advisor, in our experience of COPRAC, is not here just to hang around and enjoy the boxed lunch. You know, it's a working committee, as you all know, and the advisor does a lot of work. Anyway, that's my own tidbit, but I definitely wish for Steve, Dina, and Justin to speak to it if they want.
Yeah, I'll let Steve address that, that particular language. Maybe people would feel more comfortable saying it slightly differently. I think that what Justin described is what was trying to get at, but maybe Steve has some further insight.
Well, I don't actually have a strong view on this. I think I was trying to capture what the concern that essentially that the advisor was a kind of decorative, decorative from the committee's point of view, and sort of a nice thing to keep on the person's resume, as opposed to an actual vigorous participating member. I don't have any problem with taking that language out and saying, simply say, past experience has been that arbitrators have continued to participate vigorously, right? And just put it in the affirmative without taking on the negative perception. So it could be past experience has been that the advisor typically, or has been that the advisor continues, I would say, continues to participate, right? Does that sort of simple affirmative statement? I would take the they out. There's two of these now. Does that satisfy your concern, Sarah?
Yes, it does. I mean, but with the background that Andrew shared, I'm fine you know, if you feel it's necessary to address that concern that might have been raised. But I preferred just stating it in the positive. But I wasn't aware that was a concern before.
Well, I don't have any problem with that change. If people think it might be probing a little too deeply into a thought process we don't understand fully.
Well, you know, now that it's been brought again to our attention that the objective of all these committee changes several years ago was to better provide regulatory activities. At where the sentence ends in benefits tremendously from some continuity, I would say something along the lines of benefits tremendously from continuity, which is essential to any regulatory process.
I think the continuity point here is tricky because it's not going to be fleshed out. The continuity and should this get on the board agenda and should I be able to present, I would be able to speak to it. In my view, the continuity aspect comes up when the committee at the end of the year, without the advisor, loses the chair and arguably two or three senior members from the committee. And inevitably, at the end of any committee year, there's 2, maybe 3 opinions that are either out for public comment or ready to go out for public comment. And so we onboard new members, we're responding to public comments about iterative drafts that have been created just recently. And for me, the advisor provides such important continuity for both onboarding new members and having that institutional knowledge to respond to public comment that a lot of, when you're at a period of turnover, a lot of new members won't have that, I call it, you know, the institutional knowledge to respond to. So I don't disagree with the words you've added, Joel. I'm just not sure it's gonna, I'm just speaking for myself. I mean, I don't think ending the sentence with continuity gets at this either, but I hope the inference is clear, even for the uninitiated reader when read in context of this very helpful and well-drafted letter in its entirety.
Well, and the later sentences below that describe what you're talking about. We say that there's an example of how the process is extended and that the advisor provides much needed continuity and institutional knowledge. We say that 2 sentences further and describe that a little bit more.
I guess my concern is that is essential to any regulatory process doesn't distinguish us from any other committee. You know, all these other committees are also engaged. A lot of them are engaged in regulation, and we're not. So that's a bit my concern. And then we do get into the specifics of continuity after that. So I'm not sure that. I'm a little concerned that it doesn't quite capture the idea that our need for continuity is distinct.
Well, all I was trying to do was highlight out of my memory from the battle we lost on the Mandatory Fee Arbitration Committee, which was the inability to convince the powers that be that the function of the Mandatory Fee Arbitration Program was complementary to the regulatory objectives. And my thought was, if we can highlight that, yes, we're on the same page and we're thinking about their objectives, it might be a good thing. But I can live with it either way.
So Joel, I'll just say, COPRAC thankfully has already cleared that hurdle. And I think for the reasons Steve pointed out, my recommendation would be stick with the original language. I think Dina helpfully pointed out for me succeeding sentence after continuity. And I'm just not sure that focusing on quote unquote regulatory process is what this ask is with the committee. I think the board is aware of COPRAC's good work and what it's focused on. This pitch is that reinstatement of a single person in the role of advisor is really going to benefit the work of the committee and benefit practitioners and the public and the board, at the time at times when the board needs this committee's advice. Now I'm looking at the word some. I wonder if did we already agree to strike some continuity? I guess we should hear from others about this additional language from Joel, and then we can look at if we want to strike the word some.
So I guess as just one of the other authors of the letter, I tend to concur with you, Andrew, to remove the addition. And then in terms of whether we include some or not, I don't have strong feelings, but to me it reads stronger to just say continuity. Some, I don't know that we need that modifier there. It sounds stronger to suggest without a modifier that we need continuity, period. I'm not sure that the sum adds. If anything, it might undermine, the weight of the word continuity alone without that modifier. So that's my reaction to that. But I'm getting into some,
Well, if I were going
diction
to
here and semantics, so I don't feel too strongly about the word some, but that's just my reaction to seeing that.
If I were going to add any modifier to continuity instead of some, I would put essential. But
Right, something stronger. Some is more of a detracting type of modifier as opposed to essential, which reinforces the word continuity. So if we were going to have a modifier, I agree, Joel, we would want something stronger than some.
I'd agree with Justin on this, and just kind of watching the way this has progressed, the retraction of the addition and then the changing of some to essential, I think addresses both concerns. One, that we don't want to make this weaker language, but we do want to point out that this is something that, continuity is very important. So I think that the way it looks right now is spot on.
I agree with those comments. Does anyone else have comments about this language or any other language in the letter that they thought needed tweaking or fine tuning? Okay, hearing nothing on that. I think, David, you started by making a motion, which Andrew, maybe you can give guidance. The motion would be to approve the letter that the committee adopts. This memo would be put into a letter and presented to the board. Is that the exact, how would you want to formulate that motion? Yeah.
Yeah, I think the motion would be the committee approves the letter as modified or drafted or modified, and requests staff to submit the letter to the board for consideration. Something as simple as that. And then just so the committee is aware, this will be presented as a letter from the committee as opposed to 3 individuals of leadership. It's not a significant difference, but it does help staff in terms of how we frame the letter. So I think it's good that the committee has considered the letter and that the committee is in, depending on what the vote is, full support that they believe, that everyone here believes that an advisor is a critical function of the efficient work of the committee. And Joel did second it. So unless any further discussion, unless there is not any further discussion or comments, staff can take the roll call.
Okay. Dina Roche,
Yes.
Ken Bacon,
Yes.
Sarah Bonola,
Sorry, yes.
David Carr,
Yes.
Justin Fields,
Yes.
Toby Inlander, Adam Koss,
Yes.
Rennie Kruger,
Yes, sorry about the delay.
and no worries. Amber Lee,
Yes.
Joel Mark,
Yes.
Kyla Rowe,
Yes.
Hunter Starr.
Yes.
Thank you.
Andrew, before we move on to the approval of the open minutes, I know we still need to do that. Was there any report? I know separately you and Mimi sent out information to moderators relating to the symposium. I didn't know if you wanted to make any comments about the symposium or report on that generally to the committee.
I did not prepare, and I should have, but the general report would be really excellent across the board, high level marks of satisfaction, which I think speaks to both it being presented remotely. And well, I don't know if it speaks to it. I think you should pat yourselves on the back for the fact that we received high marks and we presented it remotely. And also, I just think the content was so well received, and the presentations were well received. But you raise a good point, Dina. I mean, we should spend a moment or two to speak about that. I don't know. I know Mimi compiled the comments. I don't know, Mimi, if you had anything in particular that stood out that you wanted to share. I don't mean to put you on the spot. If you did, now would be a good time. Or if any of the moderators or if Dina yourself wanted to provide any comments, just again, from my perspective, we usually get 4s and 5s. We get, the members of this committee always put on very strong, good, well-received presentations, but this one was the reviews were particularly high marks, and everyone should be pleased and proud of themselves. And again, I think it's for 2 reasons. One, the material was well received in the format it was provided, and also the panelists and the material was just really well put together.
I just wanted to thank the staff and also Mimi in particular for putting together the comments from the attendees, which I did forward to my panelists, and they were very much appreciated. So thank you so much.
No, I don't really have much more to add. All our programs every year are really great, but this year in particular, when I was reviewing it, I think this is probably the highest marks we've gotten in probably the last 10 years. I did do some comparison from previous years, and this year was very well received.
Yeah, it seemed like the ability to offer it remotely really attracted a larger audience of people that weren't just the typical legal ethics practitioners, but a wider range of individuals who were trying to learn more about legal ethics or get their credit. So I thought, that was what seemed like one of the great benefits of being able to do it remotely. And obviously next year is next year, but it feels like being able to have some combination where at least we have access to be able to offer it in that way going forward seems like something worth discussing, right? Whether to be able to attract those larger audiences, and in any event, that's just my thought about that. But I thought it was great. Okay, any other comments, or we can move on? I know we have a before we move on to the approval of the minutes, we do have a really ambitious agenda. I think I appreciate everyone working to turn around the opinions and get them back today. And I think in terms of, we do have some opinions that we've talked about voting out and have public comment back, which typically we might spend a little bit longer on those. But I think with respect to the other opinions that people have worked hard on, I'm sorry if you feel shortchanged in terms of the time getting to talk to about your opinion. Obviously, we'll have further opportunities in other weeks to more fully flesh out, but maybe you can think about particular issues in your opinions that you want more feedback on and concentrate on those particular things. That might be a helpful approach. And but I appreciate all the turnaround on that and everyone being engaged in this. So I guess, does anyone want to move to approve the session action summary from our April 15th meeting?
Move to approve.
Second.
Very good. Okay, Ken made the motion and Justin seconded. There's no further discussion. I'll take the roll call vote. Dina Roche,
Yes.
Ken Bacon,
Yes.
Sarah Bonola,
Yes.
David Carr,
Oh, yes.
Justin Fields,
Yes.
Toby Inlander, Adam Koss,
Yes.
Brendan Kruger,
Yes.
Amber Lee,
Yes.
Joel Mark,
Yes.
Kyla Rowe,
Yes.
Hunter Starr.
Yes.
Thank you.
All right, great. So I think without further ado, I'm going to hand it over to Steve to talk about his revisions to the client with diminished capacity opinion.
Thank you, Dina. I'm just going to walk. There's a set of issues that Justin raised in an email with me last night, and following up on some of his comments in an earlier meeting. I'm going to take those last because they sort of lead into the process of group comments and tell you what my sense about how to respond to them. But I'm going to deal first with the changes that are in the version that you already have seen. So I'm working off the red line here, and I want to give some thanks beforehand to the drafting group, and also to Sarah Bonola and to Andrew, who have both, everyone has made really good contributions in terms of changes since the last version. And I won't call out every person, but so there was a sense in the subcommittee discussion or drafting group discussion that the digest we ought to go through the digest carefully to make sure that it covers all of the things that the opinion covers, so that somebody reading quickly who might not read the whole opinion will see see the topics that are covered. So there are two changes. Another concern that Sarah Bonola expressed at our last meeting is that we want to be clear that in saying that you should try to maintain a normal attorney-client relationship with the client, that we're not trying to describe a sort of, how should I put it, a judgmental view of what a normal client relation would be, or to bring in any notions of a sort of what an ableist client relationship would be. And so the language that I came up to deal with that is it went back to some of the original literature, and the clear idea in terms of what a normal attorney-client relationship is that a relationship in which the client makes those decisions which are normally reserved to the client under the ethics rules. So you can see two changes then in the digest. One is that change, which also appears later in the opinion. But the second is to bring out more of the substance of the opinion. At lines 13 to 15, you see duties of competence, communication, loyalty, and non-discrimination, which are the duties that generate most of the obligations described in the opinion. As I looked at that, I think does a pretty good job of bringing the core of the substance of the opinion all into the digest. But to the extent that people have other thoughts about what should come in, I'm happy to hear them. So that's number one. Then, as you move over there, the only at 217 to 218 meaning is the next really significant change, and it's again the point that Sarah made to make clear that a normal attorney-client relationship in this context simply means one in which the client makes the decisions which are normally reserved to them. So that's the next big change. At the discussion of 8.4.1, which is is the next change of any significance, and that's at starting at 345 maybe. There had been a concern expressed, I think, by Ken and by Sarah that perhaps the discussion of non-discrimination was too long, and Sarah made a number of clarifying or shortening edits, which I included all of. In addition, Toby suggested that we should have a reference to the provision in 8.4 F2, which specifies conditions under which you can withdraw, and that seemed like a good addition. So that's note 14, and at note 15, Sarah had suggested that we add a reference to the Unruh Civil Rights Act, and that's also now added. So then there are some minor changes to the discussion of Sullivan versus Dunn at note 17 in response to some very helpful comments by Andrew. An important change at page 30, excuse me, I'm sorry. I'm sorry, let me find it for you. At 422, note 18, there had been a suggestion from one of the commenters that we should try to deal with the situation where information about the client's incapacity might not be confidential, and to spell out what they are, circumstances in which then a lawyer would not have to get informed consent. That footnote, we discussed it in the drafting group, and the sense was that trying to describe that situation was a bridge too far, in the opinion, in terms of taking on a very difficult topic, which is the question of when something that's customarily viewed as harmful or embarrassing might fall outside that standard. We decided not to take that on in a footnote without any authority in it, in the opinion, leaving that for lawyers to figure out on their own. Then the other big changes are in the discussion of informed consent, and they're not big changes. They're just, if you can move to, I think the first one shows up at 483, maybe. What we and I guess actually note 26 actually comes technically before that, right? The first thing I wanted to do in adding this footnote, note 26, right, which shows up right there, is that there's a lot of things that could go into this kind of opinion, right? And it seemed to me that we didn't want to try to take them all on, but that I wanted to put this in to deal with a concern that a number of people had talked about at the last meeting about boilerplate, because I don't think we want to encourage boilerplate. We actually want lawyers to think about these different elements, right? Among other things, I thought it might be helpful, given the concern that had been expressed about a check back, right? To point out that a check back is one of the things that a lawyer can think about in these circumstances, along with others. So that's note 26. it's the same idea here in 484 to 486. Excuse me, I have to, I've got some music going here. See, I am online. Sorry about that, folks. My wife doesn't have complete control of Spotify, it's fair to say, and you were about to be treated to a concert. So 44 to 486, I wanted to get in the point that that it's not boilerplate, right? That we want people to think about the relevant circumstances, but at the same time to suggest that there are some that are likely to be relevant in almost every case. And then, if you jump over, I'm sorry, I got a little distracted there. But if you, so we talk about the variation. Then at 493 to 495, people thought that the idea of the lawyer making an error in judgment was not really the risk we were describing, right? The real risk is that the lawyer makes a reasonable judgment, but events turn out differently, right? And so the rewrite, which came out of the subcommittee discussion, is to try and capture that more accurately. And then we'd had a good discussion of changed circumstances last time, and the rewrite at 500 to 505 is, and at note 27 down below, is intended to make clearer what we mean by changed circumstances, right? And I won't go into walk you through that wording, it seems, but that's what we were trying to do. That's basically the substance of the changes that we made. Let me move for a second to Justin's specific comments. Justin's concern, which I would like him to explain a little more, but Justin's concern is that the word judgment appears too many times in this opinion, and that judgment has a negative connotation. I'm not quite clear on the nature of the negative connotation. I think it's an implication that that it sort of implies too heavy a burden on the lawyer. They have to make a judgment, right, as opposed to making a decision. And so most of the changes that Justin has proposed are shifting the word judgment to the word decision, and I'll walk you through them in a second. I personally am not averse to interchanging the words judgments and decisions throughout the opinion. In the digest, I think I'd like to keep the term judgment, right? Because that's the term that shows up in a lot of the professional literature, ethic literature, on thinking about capacity. It also is the term that shows up in the sort of restatement formulation of situations where you're making a difficult choice, bearing in mind, for example, that under the duty of loyalty, you may have to actually make a judgment about what loyalty requires on very uncertain facts. And the restatement, I like the idea of tying that into the restatement and also tying it indirectly into the judgmental immunity malpractice piece of it. So those are two reasons why I would lean towards keeping judgment. I also like the fact that judgment, to me, has an implication that a client's capacity is something you really have to respect, right? That the client's decision-making authority is a very important right. And judgment implies that if you're making a judgment about it, you're really thinking about it, as distinct from a decision. That doesn't mean I want to put a lot of weight on the distinction between judgment and decision. It just feels to me that when you're talking about, for example, possibly telling a client that they can't do something they very much want to do, right? Or that you won't help them do something they very much want to do. I like the idea of judgment as applied to that, because that's a serious thing. So with that in mind, let me walk you through. Well, Justin, maybe you want to be heard before, or shall we talk them through one by one?
Sure, I can talk now and kind of give you my thoughts on the use of the word and you know, where I'm coming from and what I would suggest as a potential alternative. And I'll try not to rehash what we went over in the last meeting on this, but just to recall for everyone, we had a discussion about some of the word choices between judgment and reasonable belief and decisions. These are some of the terms that are used in the opinion. I think, as Stephen alluded to, sometimes interchangeably. And where I'm coming from is, you know, this concept of diminished capacity for our average reader, I think is going to be a complex one. And while I think using synonymous words to avoid, you know, being kind of overly repetitive in some contexts is helpful, I actually think here that having a more consistent word choice for what it is we think a lawyer must do when confronted with a client with diminished capacity is going to be, or would be, helpful to a reader trying to navigate a difficult ethical issue. And for me, trying to think about, you know, what our readers might think about these different words, I'm concerned about confusion. You know, it is, when we talk about a judgment or a decision or having a reasonable belief, are these all the same thing, or are we talking about different concepts? I have concern that, well, let me put it in the positive. I believe that having more consistent language would be helpful, and then it would also draw a distinction between this, you know, the concept of forming a reasonable belief that your client has some kind of diminished capacity and taking appropriate steps to deal with that, and other legal concepts or ethical concepts like informed professional judgment or the concept of judgmental immunity that we talk about in our opinion, which, you know, at least for me, are different. You know, this idea of making an informed professional judgment, as I think of it, is focusing on a judgment related to the legal services being provided. You know, similarly with judgmental immunity, it's about, you know, there's a debatable state of the law, and you as a lawyer make an informed professional judgment about what is the appropriate legal position that you can take, as opposed to, you know, making a judgment about your client's mental capacity. I'm concerned, and again, it may be because I'm a litigator, and so this word has a particular connotation for me personally, but when I think of the word judgment, as Steve alluded to, it has a certain weight to it that other words like decisions or taking steps based on reasonable beliefs doesn't. And so what I've suggested, and I think Steve might be planning to highlight a couple examples, is where we're not talking about informed professional judgment, or where we're not talking about judgmental immunity, distinguishing those concepts in the opinion by substituting the word, whether it's decision or the concept of reasonable beliefs, substituting the use of judgment in those contexts, so that we have a sort of a consistent diction in the opinion is kind of the approach that I've suggested as an alternative to some of the uses of judgments. And it's really, I think, only in about, you know, 5 or 6 places where I think that just wordsmithing the word judgment might be beneficial here. So this is certainly not a significant issue in the opinion, but I do think it might help with clarity for the reader. So that's my 2 cents on my thought process.
I want to stress that I think Justin's making, I'm not out of sympathy with what Justin has to say. And as we go through, you'll see, but my sense is it'd be helpful to look at the specific instances because there may actually be some, there may be some traction. So let me walk you through them, okay, if I may. In the digest, at lines 17 to 18, Justin would like to change the word judgment appears twice, judgments, right? A lawyer must make difficult judgments relating to the client's capacity, provided that such judgments are informed and disinterested. And Justin would like to substitute the word decisions. As I said, I like the idea of emphasizing the importance of the importance of the client's right to make these decisions, so that these decisions, and that's in essence, and I like to tie it in to the restatement formulation, which we're trying to make the law of California in this circumstance, or at least to lobby for making it the law of California in effect. This is a good test case. If the committee thinks we should change those words to decision, that will drive, in my view, we should then probably accept almost all of Justin's suggestions. So I'd love to have people's sense of that issue.
If I might say, I was, in reviewing this, I found myself, before I saw Justin's email, Steve, I had made a note to myself in the margin in this very first point saying decisions ? For these two things, and hadn't remembered in detail his comments from last time. So I had that instinct. And I think for me, part of the instinct to want to change it to decisions, and I understand like independent professional judgment, and I think, I understand wanting to tie it to the restatement but I feel like there is this sense when you're talking about most attorneys looking at this, and we got some of that in the public comment letter where people are like, well, why, I shouldn't be in a position where I'm judging capacity. And that's not what we're saying, but I think there can be this improper inference related to using that word, that people think they have to judge capacity as opposed to making decisions and judging and using the right tools to say, in circumstances, not that they're in some respects not asked to consider capacity, but that they're not going to be in the medical position of saying the person is incapacitated. So I think I like decisions better. And I don't know how that plays out in terms of the other comments, but to me, it feels less like that we're saying that the lawyer is judging capacity, because it's a more nuanced thing. And that's just my instinct about it. Because I think most people who are reading it are not going to be as sophisticated and going through this analysis and saying, this is, we're tying it to independent professional judgment, and it means sort of a similar thing. And it really, so that's my thought. I'd like to hear from others.
I would too.
I agree with that. I think in this sentence in particular, especially the difficult judgments relating to the client's capacity, it's almost like, I actually think the word decision changes the meaning of the sentence a little bit, but in a good way. I think it brings it more into what we're trying to say here, because I think judgments is almost missing words. Like it would be make difficult judgments as to a course of action relating to the client's capacity, because we aren't saying that we're making judgments on a client's capacity and that's it. And that's, I think that's, I agree with Justin in that the word judgment is like, it's almost like we're just sitting there judging our clients as opposed to considering the client's capacity and making decisions relating to the client's capacity, as opposed to, I guess I have an issue with judgments relating to the client's capacity. Wording wise sounds strange to me.
Can I just say one thing? I think that there's a premise under, I don't disagree with making this change, but I do think that it's important that we understand that capacity, that a judgment about capacity is a legal judgment, right? It's not a medical judgment, ultimately, because you have to apply the law of capacity to the medical facts at hand. So it's a classic case of legal judgment, in fact. It's true that there's very little authority, right, construing the relevant statutes, but the statutes are there, the case law is there. The standards ultimately are legal standards, not medical standards. And so a lawyer does have to make legal judgments about capacity. And in fact, the literature that we cite says that very clearly, that sometimes a lawyer does have to make a judgment about capacity. Now, we can put that aside. I don't mind changing to decisions, but people shouldn't be under the impression, and we shouldn't be conveying the impression, that a lawyer does not have to make legal judgments about capacity. They do.
So hearing Dina, Kyla, and Steve talk just now reminded me somehow of something we discussed from our last meeting. And I don't know how I remember something from so many months ago when I can't remember working from home, what I did 2 hours ago. But what I do remember is we discussed potentially to address this issue as sort of a middle ground, dropping a footnote and saying something to the effect of, when we use the word judgments in this opinion with respect to what a lawyer does or doesn't do when it comes to a client's capacity, we mean this and we don't mean that. In other words, some kind of footnote so that rather than having to maybe globally revise words, clarify what we do and don't mean by the use of this term. So I just offer that as another possibility to address the concern of the use of the word judgment, to drop a footnote and be more clear about what we do and don't think about it.
I like that idea, because I think that the problem with replacing judgment with with decision is that decision is based on a judgment, which implies some form of evaluation. And so if we substitute judgment with decision, it's almost as if we're skipping the part where the lawyer is making legal judgment, as Steve put it. But I think that having a simple, like a short footnote seems like a good compromise.
Could we put the word legal in front of the judgments? They're difficult legal judgments in that first sentence, if we kept it in and did a footnote, just so that we're honing the reader on the idea that we're not asking them to make medical judgments, or the footnote might provide that as well. But we are talking about legal judgments. I think that would help.
I like the idea of a footnote too.
I don't have a problem with the idea of a footnote. I think we should think about where it should go. And then if that's the sense of the group, that can be a project for me during the lunch hour. And perhaps Justin and I can talk offline. I can draft something and we can see if we get something that we think captures the sense of what we're trying to say. As I said, I don't have a problem with that. I also, as I said, don't really have a serious problem with, but I think on balance, I think that the footnote approach probably captures things better. I want to raise one other issue though, which because not everything I think is mooted by. I think that a couple of Justin's changes stand regardless of this set of issues, and I wanted to draw your attention to them quickly. First, I think in note 13, which note 13 is at roughly line, roughly line 322, Mimi. Justin raised the question of whether the use of the word judgment in the last line of this footnote, reach a judgment about the client's capacity to make the will. And he pointed to some other language in that opinion, which is well short of reaching a judgment. And it doesn't seem to me that it's really necessary to get into the question of exactly what Moore said. My suggestion here would be, and Justin, I'm wondering if this meets your concern, if we said lawyer's duty of loyalty to the client required the lawyer to attend to the client's capacity to make a will, right? And you don't have to go further than that in terms of what the case actually says. Would that meet your concern, to attend to the client's capacity?
That definitely helps. And just to give everyone further flavor for my thinking on this word judgment is I thought the Moore case was very instructive in how it described what a lawyer's process can or should be when it comes to a client with diminished capacity. And when I did an edit find on that case, whether it was intentional or not, the court didn't use the word judgment. It had it had language that, as I think Steve points to, is maybe just a step removed or a step before a judgment. And it uses, including this language of reasonable belief, which we've, I think, captured quite well in this opinion. And so going back to this, so yes, to answer Steve's question, I think that does address my my thought on that footnote. And then as I'm thinking about this, this other footnote where we're going to draft, Steve, I think it's a good opportunity for us to kind of marry these various terms that are used in the opinion, you know, judgment, decision, reasonable belief, and help the reader understand how those terms relate to one another in the opinion. And that you know, I think will be a way to kind of triage as opposed to revising words throughout the opinion. So right. As I think about it further, I think the footnote might be a really good solution.
Great. So Mimi, I think the sense of the group is then where we have that language at the bottom of note 13. Or I mean, at the bottom of it required the lawyer to, we could simply say to, instead of reach a judgment about, we substitute attend to. So reach a judgment about would come out. And then
well, I guess that, to me, that makes it a little more ambiguous. What does it tend to mean? Think about.
Well, I think what we're trying to say is, I think what I'm trying to do, Ken, is to avoid an extended discussion of what more means, because it's all dictum, and it's also not really framed very strongly in terms of the ethics rules. So the point would be simply that it wasn't that Moore doesn't give the lawyer a pass, right? The lawyer, I've talked with lawyers around in this area who say, "Oh yeah, well Moore says I don't have a duty," right? And that, I think, is a huge mistake. Right? You clearly do have a duty, you just don't owe it to the beneficiaries of the will. But I think for our purposes, it's enough to make the point that Moore clearly intends that the lawyer will pay attention to the client's capacity as a matter of the duty of loyalty.
Yeah, I still find that a little confusing. Why not? How about we just say required the lawyer to consider the client's capacity or evaluate or something? Attend to.
I don't know that it necessarily does all the time, right? That's why I choose the lighter formulation, right? Because all we're really trying to do in this footnote is to suggest that it's not, that Moore is not a free pass.
So Here's the sort of the key quote from Moore that I think this sentence is trying to get at. And I'll just read it. And it kind of, this also gives you a flavor for the word choice in that opinion. The quote is this: "The attorney who is persuaded of the client's testamentary capacity by his or her own observations and experience, and who drafts the will accordingly, fulfills that duty of loyalty to the testator."
I mean, I think that language is actually consistent with what we have right now, because persuaded implies you're making a judgment. But I'm happy to soften it, because I don't feel if you or we could use the exact language.
Well, it may also depend on how we use this footnote to explain what we mean by judgment. That might also solve the problem. So maybe this is, maybe we can think about whether we need to come back to this based on what the footnote says.
Okay. Now, I accept that, and we'll put that, move to the footnote issue. At line 402, folks, Justin had a change that I think is really good. Captures much more clearly what we're, which is, so at 402, right, we're discussing, accordingly, absent a final judicial determination of capacity, a lawyer's judgment that a client is incapacitated should not by itself terminate the lawyer's authority to take protective action. Justin suggested the use of reasonable belief rather than judgment. And I think that captures much more clearly what we're up to here, right? So we'd say a lawyer's reasonable belief that a client is incapacitated. That is a better formulation. But this, of course, ties into the larger question of whether the discussion of capacity is, of authority at this point is correct. But I would be inclined to accept Justin's change there. I think it captures the sense of what we're trying to capture more accurately. And that's all I've got by way of, if Justin and I are going to go offline and do a footnote for you during the break, the real question then becomes, what else have you guys got that you'd like to talk about in the opinion?
It doesn't sound like anyone has any other feedback. I know we've had a couple different revisions to this and with the subcommittee, and thanks again, Steve, for all your hard work and effort into seeing this to close to the finish line. So it sounds like you guys are going to make that revision to the footnote, and then we would come back after lunch and be in a position to vote it out. Is that something that, I know you won't be here, Andrew, do we need to vote it out now subject to the changes of the footnote, or what would you prefer that we do?
You can do that, just the vote. Mimi will be here, and she's
Okay.
well astute and well versed in how to do this. It's just, I would just clarify the vote or the motion should be for 60-day public comment, which is our typical period when something's out for additional public comment. And this is technical, and I don't think it's going to be an issue, but you need a majority of the committee members, not the majority of those present, to effectuate such a vote. So you need at least 7 yeses is the only other technical thing pursuant to committee rules. So 7 yeses in 60 days, if you vote and I'm not here, it should be fine.
Okay, great. So why don't we then table that for after lunch? We'll hopefully move through that quickly and be able to vote that out for another day of public, or another round of public comment. Why don't we now move to the discussion of the improper contract provisions. I'm sure most of you saw that we got several public comments from bar associations and other sources. And I believe, David, you're going to be able to present just sort of a summary of those and engage in a discussion about some of the more meaningful comments. Take it away.
Yes, and I think I'll share my screen and we'll go through some perhaps slightly inelegant bullet points attempting to summarize the comments. I'll say in general, I found all of the comments interesting and helpful. And there are issues big and small that I think we need to address. So let me attempt to share my screen. I think I see it there. Hopefully everybody can see that okay.
Yep. I see it.
Oh, good. So I'll just kind of go through the
David,
comments.
I'm sorry, I'm old and my vision is poor.
Oh, I'll make it bigger. Yes.
Could I ask you to zoom in just a little bit? Thank you.
Sure.
That's my only request. Otherwise, I can see your document perfectly.
Okay, I know
great.
that different screens it doesn't display as well.
That's
First off,
perfect
our
for me.
first comment is from Attorney Rowmaker, who accuses us, and I thought this was a fine turn of phrase, of aren't pedantry. Maybe I misspelled that. Which, after looking up the dictionary definitions of those words, I didn't think that comment was particularly. There were some complimentary aspects to that. He said his other point. He says we don't know if a non-compete clause is void until the facts of the termination are known. Other contracts, he says, not possible to know if they're void for illegality until you attempt to enforce them. He does agree that a lawyer may not participate in enforcing a restrictive covenant if employees not privy to trade secrets. So I think I'm going to present these in a neutral way, and then we can go back and look at them and express some opinions on them. My hometown, San Diego County Bar Association, contributed a comment. It recommends we add language regarding lawyers assisting in enforcing illegal provisions on third parties. It says we should add language regarding clarifying that higher authorities within the organization in our discussion of 1.13 toward the end of the opinion. We should make the distinction between illegal and enforceable, or I probably should be unenforceable, more clear. The distinction between an illegal contract provision and an unenforceable contract provision. The drafter was unclear, or to the commenter. We should add language regarding addressing acquisition of knowledge by inside counsel. And I think I added some to the draft, Rule 1.0. Discuss when a lawyer knows a provision is illegal and cite to the definitional section 1.0.1, which clarifies that knowledge means actual knowledge. And my gloss on that is that means actual knowledge, not some form of constructive knowledge, is the way I interpret that definition. Clarify where the duty to recommend against use comes from. Comment that Rule 6068D, the discussion on that is not needed. We have Rule 8.4, which addresses dishonesty provisions in the rules. And finally, that the South Carolina opinion that we cite in the draft overly relies on Rule 8.3, the duty to report misconduct, which we don't have in California. Bar Association of San Francisco, their comments: consider a third scenario where the lawyer considers in good faith that the court wrongly decided that the language was illegal and presumably attempts to, in that good faith belief, attempts to modify or change the ruling of the court. Questions whether this problem, the above problem, is curable by adding some limited language In other words, say with respect to the illegal provision, if we say to the extent lawful and enforceable, whether that somehow cures the problem with an illegal contract provision. Footnote 7 again references the statute B&P Code 6068D, not clear that it applies to transactional work. Finally, well, next point, clarification of chilling effect. Exactly what do we mean by that? They define chilling effect as an attempt to induce some kind of fear or intimidation in inducing the employee from taking action, I guess, to not comply with fear and intimidation, but inducing employee with the to accept the contract provision by raising the specter, I guess, of litigation against the employee, breach of contract litigation. They questioned, does the last paragraph on page 4 refer to an omission of material fact or I guess an omission of law? They think we should more clearly address the false statement of law issue, citing Rule 4.1b that says you must disclose a material fact when necessary to prevent fraud. And I guess the last point that are we clarify whether we're talking about the attorney committing fraud or whether we're talking about the attorney assisting the client in committing fraud by not disclosing a material fact, which gets into the 4.1 duty. To what extent is that 4.1 duty owed to someone who's not, who is a third party in the negotiation? LA County Bar Association, undated comment. Again, the distinction between unenforceable and illegal, that needs clarification. They cite the former Rule 3.210 for the proposition that Rule 1.2.1 merely carries the prior rule's policy forward. Looking at the versions of the two rules, the thing that's different in Rule 1.2.1 essentially is the addition of the word fraudulent. They are worded in different ways, but the concepts are similar. But the current rule refers to fraudulent conduct, and that particular phrase is not present in the former rule. There's a concern that this rule might subject the lawyer to discipline for a mistake in judgment. In other words, perhaps this is a bit of an echo from the last discussion. If essentially the lawyer's judgment as to whether the particular provision that's at issue here is in fact illegal under the existing court rulings, existing precedents. And a general concern about the unintended consequence of imposing or articulating this kind of duty on lawyers, whether this will essentially penalize lawyers who in good faith believe or perhaps can make a good faith argument under the law or an extension of the law for the validity of these a particular provision, depending on how it's worded. Whether we're treating, I guess, too much into the area covered by the attorney judgment rule, which normally a mistake in attorney judgment's not even a cause for a legal malpractice action. California Employment Lawyers Association, Center for Public Interest Law, and a number of entities on the employee side weighed in with a joint comment, which was largely a factual comment. They generally approved of our opinion and generally cited to some very interesting statistics on the increasing use of adhesive contract provisions in all sorts of transactions, perhaps in part spurred by the fact we do so many things online now, where many activities that perhaps 20 or 30 years ago you wouldn't be required to have any kind of written contract or agreed to terms and conditions. Now in the modern world with when many of these things are done online, terms and conditions are seemingly attached to all kinds of activities. In part, in their view, this is a motivation for why this opinion is necessary. That situation that perhaps didn't exist some years ago. And they make the points that these are contracts of adhesions, that corporate entities frequently use contracts with illegal or unconscionable terms. They cite stats that 40% of employees said non-compete clauses deterred them from seeking new employment. And making the point that lawyers are not prohibited from encouraging contracts that raise unsettled, unclear issues, which is a bit of a callback to another issue raised by other commenters, that there may be situations where, to what extent is the provision actually illegal under current law, and is there a good faith argument for why it might be legal that could be made to a court, and making the point there's no justification for an unambiguously illegal term, and you can highlight the term unambiguously here. The fact that most consumers, most employees, of course, are not going to be able to hire counsel to assist them on this kind of transaction. And making the point that there's no need to clarify for lawyers acting in good faith, because the knowledge requirement requires the lawyer to know that the provision is illegal. Finally, California Lawyers Association made a number of good comments. Again, another comment echoed by other commenters is the distinction between illegal and unenforceable contract provision. Does unenforceability mean the same thing as illegal? Making the point that some states may differ in their laws. A large enterprise over many different states may be faced with different legal standards for these kind of contracts. Citing examples beyond the employment context, non-specific advance waivers in attorney representation contracts, jury trial waivers and rental agreements, and questioning whether these also are types of contracts that could come within the ambit of this opinion. Making the point again, based on the attorney judgment rule, a single error of law should not be deemed gross negligence. Again, another point, incorporate the definition of knowledge under 1.0.1. Another point echoed by other commenters that the 606(a)(d) language is awkward. And a point I think we might have discussed at some point in our discussion, whether in-house counsel could essentially make a limited withdrawal in a situation where the entity or the specific department of the corporate entity insists on using the provision, and an in-house lawyer cure that to unlimited withdrawal, essentially saying, I'm not going to work on this particular matter, although my employment with the entity will continue and I can work on other types of matters, but not this one because of the specific provision at issue. And finally, whether discussion of reporting up the ladder in other circumstances beyond the hypothetical. We've had a rather limited discussion of 1.13 and that duty, and there are probably nuances in all those things in that discussion that could be expanded. So that's a quick, relatively down and dirty summary of the public comment. So I don't know. I mean, I'll tell you. I guess I'll tell you what I think are some of the most significant issues. And I think a significant issue raised by several commenters is the distinction between an illegal provision and a unenforceable provisions. If something is unenforceable under the current state of case or statutory law, does that make it illegal, quote, illegal, unquote, under the definition of the rule? And the point made by LACBA, whether, and I think this is related, whether under the analysis of the rule, this might subject a lawyer to discipline for good faith mistakes in judgment. And I think a third major area is the clarification of what we mean by the chilling effect. What does that actually mean in terms of what the effect of the illegal or unenforceable or unconscionable clause would be? What exactly does that mean in terms of its impact on the employee? Those I see as the sort of the three big issues, conceptual issues, as opposed to relatively fine-tuning issues that we need to talk about.
Thanks, David. That's really helpful presentation of those things. I think I agree with you. I mean, I think one of the main issues that almost everybody raised was that distinction between what do we mean by illegal. And so I definitely think whether in a footnote or otherwise, we need to flesh out what we're referring to there. And I know we had a lot of discussions about that leading up to the opinion and in our subgroup about it. And we had taken out the word unenforceable to try to avoid some of the ambiguity around that term. And yet, you know, I think it may have created more ambiguity because we, you know, I think when we were talking about something being unenforceable, it would be something that, you know, you're not able to enforce the contract because it's illegal, not because there's a good faith interpretation about whether or not some court would find that it has valid and, you know, it is valid and there's a meritorious argument related to it. So I think that, I mean, you know, we can talk about this more in the subcommittee, but I think much like we're talking about doing in the preceding opinion, having a footnote or something to define like what we mean by that term illegal. Sorry, I'm having background noise, would be really helpful here. And I don't think that I think some of these, you know, maybe my view about the LA County opinions is sort of like the sky is falling about it. We're not suggesting that a reasonable interpretation of a contract provision is going to subject someone to discipline. And I think maybe in a definition, we can, you know, more fully flesh out what we mean by an illegal provision in this context will really help and carry forward a lot of the analysis, making it clear. I also wanted to, I feel like we discussed this, David and Sarah, and I don't know if you remember, but, you know, I come back to the idea of like 3.1, and I think the public interest law referenced that sort of that rule. And I mean, when we look at it, it feels like it's just related to litigation. But, you know, I was wondering again whether there's a way to sort of tie that concept into this discussion, which is, of course, if you have probable cause or a good faith basis for an argument, that is not what we're talking about here. We're talking about something that, you know, some of the issues that are raised by the public interest sector folks about how these provisions are used. And also, we're not at the same time trying to thread that needle and say that we can say a particular provision is on its face, you know, a particular type of non-compete provision is always going to be illegal or unenforceable. And, you know, I think there was a sensitivity around, we're not going to, you know, make a judgment legally whether that's the case or not. So we were kind of trying to thread the needle on that point. So anyway, I'll move my comments on to somebody else.
I agree with that. I felt like a lot of the comment letters were that kind of sky is falling, and I actually went back and reread the opinion to try to see kind of where this scared thing was coming from, because I agreed the most with the letter from the public interest groups, just about the, you know, there are particular situations where it is clear as day that a provision is illegal or unenforceable. And I think we can talk about that distinction, but there, especially like as a transactional lawyer, like you know when you're putting a provision in a contract that is not okay. And that's what I always thought that this opinion was about that. I know this is wrong, but my client wants to do it for X reason, and we're saying you have a responsibility to not do that. So I think a lot of this fear of a lawyer getting in trouble for doing something that they didn't know was wrong or that they thought was reasonable, I just don't think that that would happen from this opinion.
Yeah, I agree with you, Kyla. I also went back and checked to see if we used the term unenforceable in the opinion, because I thought maybe we had mistakenly used unenforceable instead of focusing on illegal, which I know was part of our discussion, to focus on a situation where it's clearly illegal. I think some of the issues might, from looking at the public comments, I think it's related to the example we provided, because there are some situations in which non-compete agreements are clearly illegal, depending on the choice of law and other issues if you're using it to protect trade secrets or confidential information. So I do think that just, and Dean already mentioned this, just really clarifying what we mean by illegal and that we're not addressing unenforceable provisions. One other, I guess it was a comment of the individual, John Rowmaker made the point too, that is just inconsistent with our opinion about marijuana, and address where we're saying that a lawyer can advise a client on conduct that's legal under state law, but illegal under federal law, on our compliance with state law. And I just wanted to point that out as well. And I think we can address that to some extent when we're discussing the definition of what we mean by illegal. But the other issue that I thought was raised by a couple of comments, and I thought we discussed this as a subcommittee, but actually the draft opinion doesn't address it, is just what this means for in-house counsel. And I know David referenced this, but it was raised by a couple of the public comments, and can the in-house counsel just withdraw from that particular matter, or do they have to resign? And this comes up a lot, I think, with a lot of different issues. So I think it would be important to address that issue. My personal view on that point is that you could withdraw from the matter, which would cause you to violate the rules. You wouldn't have to resign, but the rule itself does revert to withdrawing from I think it's the language talks about the client, withdrawing from representation of the client. But I think if you withdraw from representation of the client in that particular matter, you wouldn't be required to otherwise withdraw under the rules. But we could discuss, I think we should discuss that particular issue as well.
Sorry, this is Brandon. Is there already or ethics opinions talking about just generally situations where, obviously when counsel is faced with a mandatory withdrawal, how that impacts in-house counsel, and whether, if you've got 50 issues you're dealing with for your company, but there's one course of conduct that is improper and is a mandatory withdrawal item. Can you just partially withdraw? Do you have to quit your whole job? Is there already authority on this, or would we be crafting new areas?
I'm not aware of any authority on it. But I haven't done an exhaustive search.
Same here. I'm not aware of any authority, and I haven't researched it in connection with this opinion, but
We can add that to the discussion of potential new opinions coming up.
I was gonna say, there's like a dearth of, there's so little information about in-house counsel duties. I feel like that's a lot.
That could be a whole opinion right there on how do you apply some of these things to in-house counsel.
Right.
Because clearly the rules don't seem to be written with in-house counsel in mind. And there's all kinds of areas where the rules don't seem to really fit for, but I don't know if we want to go, that big.
I mean, it's a bit of a tangent for, it's not the goal of this opinion, but it was raised enough, right? That I just was wondering if there was already some clear path that had been delineated elsewhere that I was unaware of, but it doesn't sound like it, but we don't know for sure.
I mean, one thing is we can modify the fact pattern and just say that it was like in that final scenario 4, it was like outside counsel, right, that was being asked to do that. And then we could sort of dodge this question about how would an in-house counsel do it, and maybe try to address that later and make this pretty simple with respect to, you know, outside counsel being asked to enforce it. That would be one idea.
There is the COPRAC opinion 2003-163, which is one of my more favorite COPRAC opinions, but that is specified as representing a corporation and an individual, but representing the corporation as outside counsel. But the reason why I cite to that opinion, it has it has interesting language, but it's not fleshed out, and it says that the lawyer would be obligated to withdraw from representing the corporation only to the extent necessary to resolve the conflicts of interest. So it seems to be to this particular matter in which a conflict has arisen because he's representing, or the lawyer is representing, an organization and an individual, the chief financial officer, who discloses confidential information to the lawyer that the corporation wants to know about. Anyway, I only raise that opinion if you're looking for authority, but the opinion is specified that they're acting as outside counsel, not inside counsel, but it does contemplate and discuss, without going into great detail, that you could just withdraw from that one matter or that one case and continue to represent the corporate client with respect to other matters.
I just want to chime in on the illegal fee or the illegal issue, what the definition of that, I don't know if it helps or not, but this pops up in the fee issues and fee arbitrations because of 1.5, it's unconscionable or illegal fee. And, you know, illegal is not defined in that context, but there is, you know, a body of authority from, you know, state bar decisions and some courts that, you know, a fee that's charged in excess of the micro limits or in excess of, you know, the workers' compensation statutory limits constitutes an illegal fee. I think there's also some case law out there that, you know, in certain contexts, you know, a referral fee or provisions in a fee agreement that violate conflict rules can constitute a quote unquote illegal fee. So, and I just throw that out there for context and how in other areas, even though where illegal is not defined, how courts have interpreted it. Not sure if that clears anything up, but.
Ken, I think that the Shepherd-Mullen case concluded with illegal on finding the conflict that tossed out the contract. So Supreme Court, I think, has used that word too.
Yeah.
Referring to a conflict of interest.
And I think one of the commenters, I think it was CLA, referred specifically to different types of context where we're in the advanced fee, or I'm sorry, the advanced consent context, which was what Shepherd-Mullen addressed. Part of what we tried to do with this opinion, I mean, we started out with a hypothetical from a very discrete area of law. And we tried, I think our intent was to try to scale this up so that it had applicability outside that specific context. I thought we were clear that this was an unambiguously legal provision, but from some of the comments, maybe we weren't quite as clear about that as we can be, in terms of saying this is a provision that unambiguously under the statutory or the applicable law, statutory or case law, unambiguously, no doubt, this is something that is illegal. And of course, the whole purpose of having published opinions is not only to decide the matter at hand, but also to give people guidance. So I don't think that's a stretch to say we have to look to case law to give us some guidance on what kinds of provisions might be legal or illegal. even if some other court in some other place, might come to a different conclusion.
I agree, David. My question was, I mean, obviously several people raised similar concerns. And although as a group, we might feel comfortable with how the opinion is presented, I think it would be prudent to try to address those concerns because several of the folks had them. I'm hesitant to make the suggestion because I don't, it might narrow the opinion, but to your point, David, if we could get an explicit example, which is unambiguously illegal, and use that as the example for which the lawyer is trying to include it, that could be helpful. And also, I didn't think the competence part was as unclear as some of the commenters had, but in order to protect against that, if we could make the opinion clear that the lawyer intentionally included it, or otherwise add a couple sentences to the analysis to establish why the inclusion was either reckless or grossly negligent to take away, the one-time mistake because they didn't, quote unquote, know. I think that raises other issues that I think Kyla and others have just discussed based on the lawyer's conduct, that they were to include such a provision and didn't know of its legality. But to assist in moving the opinion forward, those might be two techniques that the committee could take in order to move this along.
Well, the concrete example we had was the specific employment context that was cited in the original request with respect to what seems to be, I'm not an employment lawyer, but it seems to be pretty relatively unambiguous case law and statutory law that these kind of non-compete clauses are illegal under those rules. So we had a very concrete example. We don't have concrete examples, I think, from other contexts, and maybe we need examples from other contexts of unambiguously illegal provisions. I mean, us ethics, those of us who do ethics, kind of like the CLA comment, we see lots of stuff there that we know, because we know this area of law, that some court has said, well, you can't have this kind of provision in your fee agreement or conflict waiver, like Shepard-Mullen. But to the extent maybe we need examples from other areas. I mean, I really feel strongly that we need to make this opinion applicable outside the employment context. Otherwise, I just don't think it's real useful.
David, I thought your identification of the key issue areas was very astute. I think one of the things, I think we all would agree that there must be some cases, right, where a lawyer will know that a provision is unenforceable, right, or I should say illegal. Maybe I should start with. It seems to me that the example we put forward is a case where it's very clear that the contract provision is illegal, right, not merely unenforceable. I mean, if you look at the Arthur Anderson case, it's expressly based on a conflict between the provision itself and a provision of California statutory law. That's the definition, if you will, of illegal. So maybe we can highlight that point, right? We're not talking just about unenforceability. We're talking about situations where there is an express provision of law that forbids the use of this kind of provision. Then there's the question of knowledge. And we talked about this. How deeply do we want to stipulate that the lawyer knows? Or do we want to say something about what it means for a lawyer to know, right? If the lawyer really does know, it must be the case, it seems to me, that there's no defensible argument in support of the use of the provision, right? Or another way to put it might be that a court would look at that argument and say at once it's frivolous, right? That's obviously a high standard, and it seems to me to take the question of attorney judgment out of the picture in substantial measure, right? And it takes also the notion that you're chilling the client's right to test the limits of the law out of the picture, because in theory that test would fail automatically. And how much of that we want to say, I think is a judgment call. I don't have a view, but I think the subcommittee should think about it. And that ties into the question of whether you should use the 1.01 standard of knowledge, right, for thinking about this. And I'm not sure what the answer to that is, or how that ties in. There's a sort of a difficult question of how to navigate between this provision and the provisions about advocacy and counseling more generally. And 1.01 could be seen as a way through, but that's complicated. It's worth seeing how that works, right? So that strikes me as a really key thing for the drafting group to think about. A second thing I wanted to say is on the fraud point, right? An assisting fraud. It strikes me that, there are sort of two ways to think about this that might be helpful. One is, do you want to say something about the law of fraudulent concealment? To what extent is this a fraudulent concealment to put forward a contract term that you know to be unenforceable, right? Is there some critical fact that you're leaving out that might make this fraudulent concealment? That would be an effort to really tie the fraud analysis right back to standard fraud law, right? You're not making a representation, right? But you might be concealing something that's critical. The other way to think about the fraud piece of the opinion, it seems to me, is there is law about means consistent with truth or something like that, right? Which doesn't necessarily get tied up with fraud, standard fraud analysis. And I wonder if that could be relevant here, and if it could be relevant, and that might be a way of related concern about, could you go with means consistent with truth? Does it matter that these people are not represented? Does it matter that these people are not sophisticated, right? That it seems to me is something that could be relevant right here, which we haven't really talked that much about, right? But so that's a second question. A third question, and I'm not sure about this, but is, and I guess this ties back really to my first point about knowledge. Does it matter? We keep saying, well, it might be lawful in some applications, right? Or it might be lawful in another state, and they're going to use it in a bunch of states. Do we want to think about that kind of point? Or do we want to narrow the facts to make it clear that it's only one state, right? And that it's unlawful in all of its applications. My own view is that a lawyer who knows that it's unlawful in most of its applications, right? And that the client intends to use it in most of the applications doesn't have a pass here. But we might want to figure out how to parse that question a little more closely, either by limiting it to situations where it's obviously unlawful, or thinking about the lawyer's obligation to think about how the client is planning to use it. Finally, on chilling effect, I sent you, David, and I will send to the rest of the committee, a very, very interesting empirical study of the use of non-competes across the country that was published. I think it's in the Journal of Legal Studies, Journal of Empirical Legal Studies, one of the major peer-reviewed empirical law places. What they found was that, first of all, people use non-competes a lot in states where they're illegal. They use them a lot. And the second thing they found is that people comply with them at very high rates, even in states where they're completely illegal, right? And that is the chilling effect. The chilling effect is that you put it out there, and in fact, because people aren't represented and they don't know it's illegal, right? They end up complying. And that's, if that's what employers are banking on in putting provisions in there that they know won't be enforced in litigation, right? That really is problematic, right? And this study suggests it's a very deep and widespread problem across the whole country. So I'm going to send that out, but I think we should say something about that, right? The chilling effect is not a theoretical possibility, that the evidence suggests that chilling effect is a very real problem. And what do we think about that? Employers putting out something that is in substance, right, completely illegal, and because they know that they can bully people, essentially, without their understanding.
Is the study that you're citing the one that's cited in footnote 4 of the letter in support?
No, I can't remember Hunter well enough to know it. I'm going to send it around. I think it's not. I think it's something newer than that. I'm not even sure. I don't think it's in their footnote 4. I think it's something even more recent than that. But I will shoot it around. People can have a look. It's a very broad-ranging study with a lot of data. Looked at a lot of different situations.
Well, I think that could make the opinion a lot stronger. Just with respect to the point you made about I think the means consistent with truth, B&P Code section 6068D. I took out the references in the draft. I did locate some authority, some state bar court authority, that section only applies to acts as an advocate, not transactional work. And in fact, the language of the statute is very close to old rule. I'm not quite up to speed on the new rule, old 5200 trial conduct. So I don't think the 6068D language, that language has a nice ring to it, but I don't know if that's the best support. And I certainly like the 8.4 language better. I think it's less ambiguous.
I think that's a very good judgment. My main thought is really about trying to get at the notion of whether fraudulent concealment matters or whether the complete lack of sophistication and lack of opportunity to investigate on the part of the employee should matter too.
I don't know if it helps, but I was looking at on the illegality issue. I was just doing some quick research when we were talking. Civil Code 1667 actually has a definition for what is an unlawful or illegal contract. And it says, contrary to an express provision of law, or contrary to the policy of express law, though not expressly prohibited, or otherwise contrary to good morals. I don't know that last one helps. And then in the cross references in the discussion, it talks about contracts and restraint of trade under B&P 16600. So that's the non-compete clause as a form of an illegal contract. So it might help to have, throw that in. I don't know, is it, is when we're trying to define what is an illegal contract?
Well, I thought that statute was going to be super helpful till we kind of got to the last part. And that's kind of the problem with some of this archaic law. like 606A, which dates from the middle of the 19th century. I don't know how old that statute is, but it sounds like it's maybe of similar provenance. When we start getting into questions of morality, it just sort of confuses everything.
It was enacted in 1872.
Oh, well then, yeah, I think that was the first rewrite of the civil code, if I remember correctly. Well, I wasn't around then, but I've been told.
But it does say that it's current, so.
1872, good enough for me.
I was kind of chasing that statute down that you mentioned based on the citation to the People versus McHale case. And I came across the 17200 of the Business and Professions Code and the Bill Lockyer versus Fremont life insurance case, which basically says that 17200 is kind of the catch-all for the unfair business practices. And that seems to be kind of the direction that the letter in support takes. So I think that that's something we should probably be taking a look at.
Is there any other comments or on either new issues or other issues? We're probably going to wrap up this discussion shortly. And then what I would envision would be that the drafting team would get together and, consider all the comments and the public comments and then the feedback in the meeting and come up with some proposed revisions for next meeting for our discussion then.
Just a quick point.
I just had a quick
response. Oh, I'm sorry. Go ahead.
No, please, Steve, you go ahead.
I was just going to say, Hunter, in response to Hunter's question, it appears that what I've been looking at is another version of the same thing that's cited in Note 4. I don't know how much the data. I don't know how the data in the two studies, Note 4 of the employment lawyer's letter. And I'm not sure how much the data in the two studies differ. But anyway, I'll send this around to people, and then obviously the drafting committee will look at it.
Yeah, Steve, I put that article that you sent around. I put the link to it in the chat box too, because somebody was asking about it. So hopefully people can access it.
I think it's going to give you something very similar to what's in Note 4 of the employment lawyer's letter that Hunter was asking about.
Yeah.
I was just going to say really quickly, someone made a comment, and I apologize, my internet connection here is very weak. So if you guys can't hear me well, I apologize. But someone made a comment about just fleshing out a little bit about reporting up the ladder under Rule 1.13. And we have the section duty to report up in an organization. Although obvious to most of you on this committee, I did think that was a fair point for an uninitiated reader who might come across this opinion. There are other authorities and resources to find those duties and how to fulfill them, but just a recommendation, I think it's helpful to add a short additional paragraph about the steps to take when, as dictated under the rule, for when reporting up the ladder in an organization. I thought that was a fair comment, and I would encourage us to do it.
Yeah, I had a concern about that too. In the last paragraph of the conclusion, where it talks about if the lawyer concludes that it's a violation of law and it's reasonably imputable to the organization and likely will result in substantial injury, they must report the constituent to a higher authority. But then that last part, unless the lawyer reasonably concludes that it's not in the best lawful interest of the organization to do so. I was trying to think of circumstances where if you know it's illegal, you know it's imputable, and you know it's going to result in substantial injury, when would it not be in the best interest of the organization to report it up the chain? I couldn't figure out a good answer to that question.
Does that language come from the rule itself? We don't have to take the time. hash this out. I'm sensitive to Dina's comment about moving this on. I wonder if that language comes from the rule itself, Ken, and that might be why it was tucked in there. But you raise a good point, and I'm not sure what it would be. But anyway,
Yeah,
if the drafting team wanted to,
the higher up people are involved in perpetuating those problems, and so it would be sort of fruitless to raise it to their attention if they were people that were involved in causing those problems in the first place, potentially, right? So sometimes, or it's just the sort of catch-all. If you have a good reason not to do it, I don't know, then it's still okay. Yeah.
it's at the back end of 1.13b. It does have that caveat.
Yeah. Yeah, it's part of the rule, but. Okay, well, if there's any other comments that people have about this, I think we have at least some good direction about where to go with this, and can circulate it and then discuss in more detail at the next meeting about proposed revisions. Okay, all right, so why don't we move on to the consideration of new opinion and arbitration advisory requests. We're kind of at a point where we have several opinions that are, maybe more midway through, and we want to make sure that we're not in a position where we're finishing off opinions and we don't have other opinions that are at different stages, which always makes it easier and more beneficial, I think, to our process if we have opinions at different stages along the way. So we wanted to have discussions about new opinions. I believe Mimi circulated as part of the agenda materials a list of the opinions that we considered before or requests that had been made. So that's a starting point. And of course, any feedback people have about new opinions that they want to raise or suggest, this is certainly the time to do that and try to maybe pick a couple opinions that we can start getting outlines fleshed out for. So Mimi, are we able to put that list up on the screen? I don't know if the best process would be to go through that list first and then ask for new requests, or I'm open to any process about it.
Right, I'm opening up the document right now. I just don't know
Okay.
where the screen went. Oh, it's over here. Oh, show on. Give me 1 second. Sorry, I'm trying to. Oh, that's not what I wanted.
Well, maybe we can just start with, does anyone have any opinion topics that they've thought about that are not on that list?
Can you see it now?
Yes.
Okay, just making sure. Do we want to add the one from earlier where you guys were thinking of maybe having an opinion on in-house counsel duties?
I mean, I think that there's a lot of interesting issues related to in-house counsel stuff that, and as we've discussed and someone pointed out in that discussion, that the rules don't always seem to be written for in-house counsel, or sometimes not written for some of these attorneys that play different roles, like, in public interest context or working for the government. That they seem to be, a lot of them focus a lot on litigation aspect of attorneys, but I think that's a good topic. I don't know if it would be more broadly like some ethical issues that arise related to in-house counsel relationships, or to focus on particular issues. I mean, there's a lot of issues that arise, ethical issues related to in-house counsel relationships that are unique to those relationships.
I think it's certainly would be a worthwhile opinion. My concern is it could be 50 pages long if we try to talk about all the different ways the rules don't really fit in-house counsel. I mean, it's a very large topic area, so I don't know if there's a way to cut it down to something more manageable. It's, it could be potentially quite large.
Yeah, and I haven't attended any, but I know there are some CLE programs focused on ethical issues for in-house counsel. And it'd be good to maybe, I don't know if any of us are in-house counsel, but it would be good to get feedback on some ideas for that topic. I do like the idea, but it'd be good to narrow it to issues that frequently arise with in-house counsel.
Yeah.
I don't know them offhand, but it would be good to get some ideas from in-house counsel or ACC or other organizations.
Yeah, I mean, I think there's certain issues always about making sure identifying who the client is, right? You represent the organization, not, typically we saw that come up in the context of, Elizabeth Holmes most recently, if you're following the news related to that trial, and making sure that they've identified that. There's always questions, I think, about privilege and making sure that which hat are they wearing? Are they the lawyer hat or are they the business hat? And so some of it is tied to rules, and maybe that's more of a best practices kind of thing, but I'm just trying to think about a way to talk about, attorney-client privilege and some of those other issues about identifying clients without having it be a best practice and being helpful to in-house counsel. So I don't know. Maybe some of us could give that a little bit more thought about narrowing the scope. Like David said, I mean, we could have, there's a lot of good topics related to it.
I have a topic. I'm not sure that this is a good topic, but I think it's something that could be really interesting. I get a lot of questions about. Oh, shut up. I don't know what that was. This is supposed to be off, but somehow it didn't get off. Okay. The question has to do with the criminal defense and the line of cases that come out of People versus Meredith, which some of you may or may not know. This is about what happens, what a defense lawyer's obligations are with respect to evidence in the case. In the lead case, the lawyer's investigator took a wallet from a refuse bin, and the court held that they took it. Okay, they have to turn it over and they have to say where they found it. Then there's a series of interesting cases about, and I think it's an area where there probably is room to be very helpful to lawyers specializing in criminal defense in walking through how the body of case law bears on their decisions about how to investigate their cases and so forth. Anyway, I put it out there as a possibility.
That sounds like a good area for an opinion. Just thinking about our ethics opinions, we don't have a lot of opinions that address criminal law issues. So I think that sounds like it could be a good one.
It's very rich. The cases do not by any means exhaust all of the issues, and leave some very interesting ones unresolved. So I put it out there. It will happen after my time, but I think it's definitely worth exploring.
I often feel exactly the same way.
I was going to say, Ken, were you about to speak, or you just want us to hear all that good noise? Did you want?
Yeah, I was just looking at
I was about to speak, and then my granddaughter decided she doesn't want to take a nap. So I reached out to the fee arb staff of the State Bar about potential advisories. And I got some feedback that there are a few that need to be updated. to reflect some of the rules changes. I think the indication is the new numbers were put in, but there might be some tweaks that are needed. And that at a training session, someone raised an issue of how to handle mediation confidentiality during an arbitration hearing relating to the Cassell case. They probably need to flush that one out a bit more. That's a possibility for an arbitration advisory. And then something was recently brought to my attention. I'm not sure I can articulate it at this point, but there's in the workers' comp and labor field, there's a thing where they do carve outs for workers' compensation. So it's the union and a employer essentially create a separate, they reach an agreement to go, resolve things through this carve out system. And I'm just starting to get into it. There's ombudsman provisions, but the issue being lawyers who have negotiated these carve out provisions for the unions are then acting in these positions where they're now making the administering, I guess, for lack of a better term, these carve out programs. I don't know that I could, like I said, it's just been brought to my attention. I thought it was a interesting issue. I'm probably not articulating it well, and I'd have to probably put it more in, give it a little more thought and put something on paper. But I thought it was an interesting issue that probably needs to be looked at, because my first blush was, it seemed when I was reading this, it sure seemed like there were conflicts involved in how these agreements were being drafted and the roles of law firms and then administering these carve out provisions. Then the only other thing that popped up, this popped up and I discussed it with Andrew a little bit. And I think we had touched on it in I think it's Andrew had mentioned in a prior opinion, but I've been getting a lot of questions about lawyers soliciting favorable online reviews from clients. That was touched on a little bit in I think it was like 2019, I forget the exact site, but that was in a different context. 2019 199 was what I think the context they talk about there was where the lawyer was asking someone to post a favorable review that was false. The issue that I've been asked about a number of times recently is, can you ask your clients to post a favorable review for you, and what are any issues relating to that? I know there's some out-of-state opinions on that, and I've seen a few articles, but I didn't really see anything on point in California.
So I guess the idea would be that perhaps that violates Rule 7.2.
That was the issues that where I've seen it discussed in some of the other opinions. I think Texas had one recently. I've seen some article. I think New York State Bar had something. There's a representative opinion on that. Just the ethics of asking your client to go out and post a favorable review for you. Is that something you can do?
Well, I've seen that arise in different places. I think, at the conclusion of the representation, I've seen lawyers ask the client, if you were happy, please post an online review. I think it might make a difference when the request is made. I've also seen, and I think this is very problematical, lawyers who say, well, I'll discount your bill
Yeah.
X number of dollars if you post a positive review.
Yeah, I think that was one of the issues I saw pop up in some of the commentary when I was looking into this issue, is that question. You know, basically offering something to them in exchange for the favorable review. Anyway, those were my thoughts on potentials.
Great, Ken, thanks for sharing those and for asking and reaching out to the arbitration folks about ideas. Others?
My granddaughter is now asleep.
Of course she is, because you're done talking, right?
Dina?
Yes.
Yeah, the only one I looked at the list that kind of caught my interest again, not that I want to try and do lawyering in El Salvador or chase down ransom payments, but the ethics of cryptocurrency. I mean, that's a subject that I'm old enough to be totally ignorant about, but I'm wondering if it's going to be of interest greater and greater as we're going forward.
Like how to accept payment by cryptocurrency. Can you accept payment? That kind of thing. Mimi, can you scroll up to the beginning? I can't remember where that is in the.
I think it's below.
Oh, okay.
Yeah, I think that the only place I've actually heard it come up is what happens when the cryptocurrency market is so volatile that it becomes an unconscionable fee when it's actually cashed or paid over. In other words, if you contract and say at the conclusion of this matter, I will accept 10x cryptocurrency, and by the time the matter is concluded 6 months later, 10x cryptocurrency is worth 50 times that. Have you charged an unconscionable fee? But there might be other issues, but again, I'm confessing my complete ignorance about the entire subject matter, but it is something, especially when I read the other day that El Salvador now has accepted cryptocurrency or Bitcoin as the official currency of the country. I just thought it might be something we want to take a look at and just consider whether it's of interest to us or will be in the future.
I mean, my first thought was like, it seems to be a matter of contract, right? If you agree to do it, you'd set the parameters for how it would work. But you do raise an interesting question about if suddenly it results in the lawyer getting a windfall, whether that's an unconscionable fee or not, you know?
I would just note, Prec did an opinion on this maybe a year and a half ago, dealing with some of these issues. And I don't remember if it's how exhaustive the analysis is, but there are a lot of issues that come up with, and we might have our own take that's different from, Prec. But one of the issues is cryptocurrency currency, or is it property? Meaning, how does it have to be treated by the attorney? Is because Bitcoins are like individually identifiable, so it's got some indicia of property that you'd have to like safeguard, and then it's also got indicia of fungible currency, and it's uncertain, obviously, how it would be treated. That IRS treats it one way, I think other authorities treat it different ways. But there's a lack of opinion out there, which maybe we should look at and see if it's leaving unanswered many questions that occur to us, or if we disagree with it.
Yeah,
You just raised another question with me is, what about something that's required to be deposited in a trust account?
Right. So the lack of opinion talks about that, and I don't even remember the conclusion actually, but it was highly controversial, even within. I mean, everybody views cryptocurrency differently, and there's no definitive authority on it, and it is determinative, how it has to be treated under the rules too. So it's a tough area, but I think important. I mean, a lot of law firms take cryptocurrency for fees.
And does anyone want to talk through some other suggested opinions, topics? I think last time we had trial publicity on there, Hunter, that you had raised a question about maybe an interest in that. I don't know if that's still of interest. I'm trying to look through the list.
It is, and specifically, there have been, I'd say, significant discussions on influencing a jury pool and the way in which that's done. I'd like to look more into the opinions that have already been published in that regard and case law in that regard before I delve too deeply, but I am still interested based on some of the things that have happened in the last couple of years. I think more could be said about it.
So is that something you think we would want to consider for selecting now and try to work on an outline, or do you want to pass it over till next time we do new opinions?
I think we should pass on it for now and do it maybe next time we look at doing new opinions, because I don't really have it's kind of a nebulous concept at the moment.
Okay. Andrew, I know in the past we've kind of gone through the list and said, like, do we sort of made a decision about a disposition of a topic? Do you want us to do that this time? Is that the sort of the protocol that we should follow?
Usually that's helpful. Just as a point of education for those who haven't gone through this, there are often times where there'll be a topic that's not quite ready to be accepted, but the committee doesn't want to cut it loose. And so they say, hold on to it for future consideration. And invariably, 2 or 3 of those topics get held on to for a very, very long time. I don't think when I reviewed the list last week, I didn't get the sense that there were many of those, but yeah, if we want to take a quick look and there are topics where we don't wish to pursue it. So there's one we considered last time about law, and it's a hard concept to get my mind around. Law firms that have 2 offices and they take higher, more profitable cases with one, and they send less profitable cases to another law firm. If that's an opinion that someone on the committee is inspired or motivated by, we could keep it around or vote to try to develop it. But if it's opinion that's not inspiring or motivational to the group as comprised today, maybe that's one we can take off the list. So that's just one example, but there are some topics here that we can maybe make a final determination on. One thing before we do that, I don't even know how to articulate it, and I fear opinions for best practices because I know that's not what we want to do. But I wonder if and I don't even know if there is an opinion on this, but client trust accounting or duties under Rule 1.15, if anyone might be, I don't know if anyone has a topic that comes up there. Maybe an ethics opinion isn't the best place to address this. Maybe an article is better. But there's just such limited authority about lawyers' obligations and duties with respect to client trust accounting. I think that's a topic that would be worthy of pursuit if there was anyone who had an idea associated with that. I'm sorry that I don't. I know one topic that comes up a lot is taking the electronic or credit card payment, which is a discrete topic, but could be undertaken, especially with law pay. I know Adam talked about this a couple of times back when we were considering new opinion topics. That's a more agreeable way to take credit card payments. The concern there, of course, is we don't want to name a particular market participant in an opinion as being ethically proper and, you know, tilting lawyers to a particular vendor. But anyway, I just want to raise the topic of client trust accounting. If anyone here has come across issues or has ever thought in the past of a topic related to client trust accounting that might be worthy of developing into an ethics opinion.
Andrew, I deal with that all the time, and it's hard for me off the top of my head to see, you know, what the toehold would be. I think there's really quite a bit of authority, very specific authority in 1.15 and the State Bar's own client trust accounting handbook on how you do that. So obviously this is, in view of yesterday's news release, this is sort of au courant. But I will tell you my feeling, and I think on our defense counsel listserv, we actually had a discussion about this, is that this area is pretty well mapped out. So I'm not seeing an obvious topic on client trust accounting.
I'm sorry,
Yeah.
my internet's slow. I missed what you said. The last phrase I caught was obvious topic on client trust accounting.
Oh yeah, I don't see an obvious. I mean, I don't see room for a helpful opinion. I think that area. I mean, if we're talking about the specific record keeping requirements and how you maintain a client trust account, I think that's pretty well laid out in the rule and the State Bar's own client trust accounting handbook, which is 110 pages of absolutely fascinating prose. So I'm not sure. I mean, was there some specific issue that you had in mind on that?
No, I thought maybe, you know, just a simple hypothetical about someone who failed to keep, you know, proper records and discussion as to what they could have done under or should have done under that hypothetical. Not anyone in particular and not any type of approach, but just a digestible way for someone who wishes to learn about or get their arms around the topic and understand better what the obligations are just in a general sense for client trust accounting and record keeping. I mean, to your point, you're absolutely right. They can go to the client trust account handbook. I just worry that it might be lengthy and dense, and that, you know, people might there be a way to draft a 5 to 7 page ethics opinion, which could, in a more digestible manner, tackle it. But I absolutely take your point that all the details might be in the rule themselves, or there's not much of a toehold there. I just raised it for the group's consideration because I think it would benefit lawyers and clients to have something like that out there.
I think it may be some kind of article, and maybe a very timely article now that the specter of random trust account audits has been raised.
Yeah, that absolutely would be fantastic. And we have venues for publishing articles, and it could come from the committee, and it would look very good on the committee's behalf. But I don't know if anyone would be willing to volunteer or feel comfortable or confidence in the right word, but could tackle that in an easily, quick, and digestible, thorough manner.
Yeah, I can volunteer for that assignment.
David, that would be great if we could do an article on that, and we would make it prominent as a resource on the ethics page of the State Bar's website, and of course distribute it through all our communication channels. And you could get the benefit of the committee. You come up with a draft, we can bring it back. It could be the work of the committee.
Okay.
Or we could work on that. I mean, it could be the work of you. You could be the byline for sure, but we could take the committee's. You could have the benefit of the committee's input and knowledge.
Would it be something that we would add to the agenda for the next time?
Yeah, why don't we do that?
Okay, if you
Just
could
call
just give
it
me like a title of
additional
some sort, David.
Sure, I'll work
That'd be
with
good.
you on that.
Yeah, I'm not real good at titles, but I'll think of something exciting.
Okay, I really appreciate that. I'm sorry to have spent 7 minutes on that, but I think that would be a great resource if that could take place. So Dina, you asked the specific question again. If there's something on here that someone's just like, no way, let's decline to opine. That's helpful. But if a lot of these are still hard to let go, and we want to keep it, we can. And if anyone else had a topic that they've been ruminating over that they have not yet been able to share, we should probably do that now as well.
And I also, before we kind of go through this list and decide on opinions, or advisories, maybe we pick 2 or 3, depending on how we feel about it. I would strongly encourage people that either are not a lead drafter on an opinion, or are, their opinion is sort of further along, to volunteer to be a lead drafter or a co-lead drafter with somebody, or be involved in the working groups for these committees. The idea being that I know we're going to hit a point pretty soon where the transition of some of the committee members are going to transition off and take different roles. And so it's really important that, newer members and members that are going to be around are more active in this process. And so that we can kind of pass the reins. And then of course, leadership is going to be working with, involved with these opinions and help with the working groups. And that's sort of typically how that role works best. And that the leadership isn't taking on lead drafter for, significant opinions going forward, that they're more acting in advisory roles and helping with subcommittees and giving feedback. And that tends to work best for the committees. We want to encourage, everyone to be involved in that process as you think about these opinions and think about maybe one that you'd like to work on, or, be a lead drafter on or co-lead drafter on. So that's my big pitch for involvement. Do we want to look at, to start at the beginning of the list, and maybe hopefully kind of knock some of these off or pass on them or something? Does staff still feel this topic needs to be addressed, the disaster one, based on the other opinion we've drafted?
So that's my note in blue.
Yeah.
I personally think this is being sufficiently addressed in 20-0004. And I don't think anyone asked for this, so that we don't have to respond to someone with a decline to opine letter. It's just, should we take this off the list because these topics are being addressed sufficiently in that other opinion?
Yeah. Okay. Does anyone have a different opinion that we should take this up? Because I would agree with you, Andrew. Okay, so we'll move on with that. This one is one that I've never really, it's always been very unclear to me about what they're really asking. And so I think we passed on it last time. I don't see us doing it this time, but if someone feels strongly about it or understands it or sees an avenue related to the facts, definitely speak up and advocate for it.
So these next 2 items, 2 and 3, are requests staff received. And I agree, if you'll see in other examples, the Ray line tries to be a little more discreet and explicit. I couldn't articulate the issues well for either 2 or 3 personally, so I just cut and paste. Both of these are the language as presented. Okay. So I'm hopeful that, I don't know, that's the best pitch I could make, was put it in their own words.
Does anyone see something in opinions 2 or 3 that they think is either worthy of an opinion or sort of a spin-off, if they understand what sort of being focused on here, or thinks it's valuable enough to sort of save it for the next iteration? Okay, having heard nothing, I think we move on to the next
So both those should be declined to opine, Mimi, if you're taking notes.
This one is a staff one, so do we need to decline to opine?
No, so row 1 can just be
Okay.
deleted. Yeah,
This one's going to go to decline to opine, is always this one?
correct.
Okay, let's go on the next list. Okay,
Okay, gifts to Indigenous clients. Sorry, indigent clients, Jesus, excuse me. Is that, I think that's one that Steve had pitched last time and now I don't see him here. So maybe we should just pass on that and keep it on the list. Although I shouldn't say that. Somebody else might really feel they want to write an opinion to that. I think he had a particular angle, but that doesn't mean that, you know, we can't consider it in different ways.
Dina, do you recall what Steve's general take was going to be on that on the proposed topic?
I don't recall that. I feel like there was something related to the ABA rules and we didn't have that in California, but he still felt like there was room to have further discussion about it. That's what I recall specifically. But when, oh, there he is, Steve, gifts to indigent clients. What was your pitch about that?
Oh, I actually think this is a slightly different thing, I think. If we're talking, which one are we looking at here? 50, oh, yes. The reason I think it's appropriate, see if I can do this in 60 seconds. I apologize for taking so long. The issue is whether a client can make a lawyer can make a gift to an Indian client, buy them a suit if they're going to, if they're going to be appearing in court, get them some money for the commissary if they're incarcerated, buy them a meal. Those are the kinds of questions we're talking about. There was a discussion in the second commission about this issue. Toby Inlander was on the subcommittee. It was a distinguished subcommittee that had Toby. I think it had, I can't remember who else, but it was a great group of people. They said, you should be able to make de minimis gifts to indigent clients. I was voted down 8-7, a close vote. The ABA has recently put out a new version of the relevant rule. I believe it's 1.8, but I'm not sure. Portion of 1.8, which permits such gifts. Now, under tight restrictions to make sure that they're not used sort of as a means of circumventing the rules about helping clients with their expenses, or to use as a recruitment tool. In fact, the promise of gifts. So it's pretty carefully restricted. My own sense is that, first of all, the commission vote was wrong in my view, as somebody who now has an indigent client. It strikes me as exceptionally obnoxious to say that I can't buy that person a meal. But apart from that, the ABA rule and our commitment to trying to maintain at least some kind of coherence in terms of national uniformity, I think requires that we consider whether we should propose the adoption of some version of the ABA rule. This is our job, is to look at new ABA rules and where they seem to make sense to propose them. So this feels like a project for the committee, which somebody could take on in lieu of an opinion, and it would be very consistent with the committee's mandate. That's my sense of how to approach it. Sorry to explain.
Thanks, Steve. Is anyone interested in considering that it sounds like we may not have the ethical rule to support that, but you're talking about trying to make a change consistent with the ABA rule and whether we want to consider.
I think the question for the committee would be, is it appropriate for us to consider new ABA rules because part of our mission is to keep our, is we're sort of one of the keepers of the rules. And should we work up a proposal to that effect? And I recognize that that's not necessarily all in our bailiwick, that Andrew and Randy and me and others would have views on whether that's something we should be doing. But it strikes me as a very worthwhile project and equivalent in terms of scope or importance to writing an opinion if somebody were interested in taking that on as something they wanted to shepherd.
Is anyone interested in that topic, or should we pass on it for now and keep it on the list?
I think we should at least keep it on the list.
Okay. All right, let's keep that on the list and the trial publicity on the list. We already talked about that 100, but we didn't. So I don't know what the next one is. And I know we kind of want to move through these because I'm sure everybody is anxious to go to lunch. So I'm just wondering if maybe we shouldn't go through all of them now, but just focus on a couple that we would, try to. Is anyone interested in any of these topics in terms of helping develop an opinion, either with a group or on their own? They could speak up. That would be helpful. I'm trying to short circuit this process a little bit.
Mimi, would it be possible to email this to the group, this revised list? And so maybe if people aren't expressing interest now, we could follow up.
Sure. I can email it to you guys right now.
Yeah, maybe that's a good idea, sir. Maybe we should just do that, and then we'll take a lunch and then try to squeeze it on the agenda after lunch for something. I'm kind of interested in some of the in-house counsel topics and would be willing to sort of co-lead with somebody on that. If somebody would be interested in doing that with me, you can email me offline and tell me that.
I'm interested in that topic 106 about if you have a conflict, can you refer the potential client to someone else? I don't know if we want to wade into that because I've just heard so much disagreement over that over the years.
Oh, really? I was like, I would feel like that would be really simple, which is, I think you can, but right. I mean, anyway.
A lot of people think you cannot. I just thought it was really, I don't know if we can add value because we might just run into the same lack of authority but
yeah.
I am intrigued by it.
We might get you more uniquely worded letters from local county bar associations.
Indeed, we could.
I'm interested in this question in number 6. I don't know enough about it to know if it would make a good opinion, but the way that it's worded, I'm like, yeah, this is interesting, calling yourself an advocate and what are the legal ramifications in different areas for that. But whether that's a ethical opinion question, I feel like I'm still a little too new on the committee to know how to pick a topic. So
yeah.
The most important point for picking a topic is that you are interested in it and would be willing to pursue it. That's number one. I know we're in a rush. I mean, the other thing to consider about opinion topics generally is how broadly applicable are they to practitioners and the public generally. That's not to say that discrete and narrow topics aren't worthy, because those are oftentimes the most difficult topics or difficult ones to navigate through, are discrete and narrow ones. But on the other side of that coin is how many practitioners and members of the public would be affected by a topic such as this, because as you know, it takes a lot of committee time and resources to develop an opinion. So that I'm not trying to put my thumb on the scale either way with respect to that, but it is something worth considering with respect to any topic.
I suppose it could be broadened a little bit, like an opinion about the words you use to represent yourself to the public. But I don't know if that, again, how useful it would be, because I think it's pretty I think people know about, advertising and those kinds of rules, and we probably have other opinions about that too.
Yeah, I mean, Andrew, you make a really good point. The other point I'll make too is that, sometimes we see something like, that you were drawn to this, Kyla, and Brandon was drawn to this other topic. And, that's why the process is such that you have an outline and you do research. And sometimes it comes to you present it to the committee at the next meeting. You're like, hey, I've looked into this topic. It's really interesting, but I don't think it's going to make a great opinion for these reasons. It's better as an article, or else it's too undecided. So that's okay too, because we're at least sort of exploring it and deciding where we want to go, so that we're not investing on resources. So you don't have to look at it as like, well, I don't know if I want to go down that path because it's going to take so much time. It's the initial path of figuring out whether it's going to be a viable topic is what the next time you present the outline would be about. So with all of these topics, I think people should consider that too, which is like, if we picked a topic that sometimes you realize that it's really not appropriate for an ethics opinion after you've dug into it a little bit, or you have a new angle that's different than what the committee really first took on and decide you want to go in a different direction, which makes more interesting sense. And so just to keep that in mind as well. Okay, so I think what we're going to do is, unless anyone has any final comments, I know we're losing Andrew for the afternoon. I hope you're okay with us picking some topics without you, Andrew.
Absolutely, absolutely. Only other observation, sorry, Dina, don't mean
Yeah,
to
no, go for it.
is so we have two opinions right now, which are kind of fees related. We don't have any arbitration advisories. So just a request of Joel and Ken and Brandon, to the extent he has input over the break, just consider whether any of the topics raised by Ken might be worthy of an arbitration advisory, or if any of you have a topic for an arbitration advisory that might be worth developing. I think it's important, if possible, to try to have one in the works.
Yes, I agree with that. So thank you. Maybe we'll circulate this, and then I think after lunch we'll break until 1:30. We'll reconvene for lunch, and then I'll just adjust the schedule. I'll look at the schedule. We'll try to make some adjustments accordingly to the schedule going forward. Hopefully we can figure out a couple opinions, and I know there's those revisions to that Steve and Justin are working on, which I don't think will take a lot of time to review and vote that out. So all right, have a good lunch.
Quick comment for Joel and Brandon. I forwarded the email I got from Isabel at the State Bar about potential advisory topics, so just check that.
Great, thanks, Ken.
All right.
All right, I gotta leave early, everybody.
Have a great time,
afternoon.
Andrew.
Thank you.
We'll see you guys at 1:30. Okay.
All right, everybody, take care.
Bye.
Technical mess.
Okay, so I've resumed the recording for the meeting. 1 second, let me share the screen so you could see the opinion. Do you see it?
Yep.
Yes.
Okay.
Okay, so there are two changes. I hope that one is a new note 4. There you go. So in this summary, we've changed the lawyer's obligations in making judgments or decisions relating to the client's capacity. And then we have a new footnote, which I'll just let you folks read, assuming you can all see it. Any comments or thoughts on that?
It's my concern would be the legal judgment.
Yeah, it is a legal judgment because there's a law that defines what needs to have capacity.
Legal judgment.
Do people feel like this addressed the concerns around the conversation earlier this morning? Justin and Steve and I conferred over lunch about this language, so I think we're on the same page about it, but we certainly want to make sure everyone else feels comfortable with it.
When I read it, I think it addresses the discussion earlier.
Now, so that's number one. The second, Mimi, if you could move to the second one, it's at note 9. And this is something that occurred to me. There we go. There it is. This is just that, in a way, it's arguably surplusage given what we said above. But it seems to fit naturally in here as well. So I'll just let you read it. I personally think we could leave it out, but I think it's also good to reinforce the point, because I think a lot of lawyers will have anxiety that we're asking to do something that they're not able to do. And I think it's reasonable to put it in here at the point where we stress that lawyers sometimes do have to assess capacity.
Steve, just so that it's clear that we understand that this is somewhat repetitive, maybe we can start that section with as noted in footnote, whatever, it was a 4. Okay, I'm comfortable with that. But I think let's hold that, because I'm perfectly comfortable with that, but people should read and see if they have another. It takes a slightly different slant here to address what I took to be one of Justin's concerns, which is that the case law sometimes suggests you don't actually have to use an expert. And we want to be able to make clear that we're not ruling that out. Does anyone have an objection to the inclusion of Ember's suggested language before we do not suggest? Simply say, as noted above in footnote 4.
I think that sounds good to me.
Yeah, my only comment on that, the last part there, consistent with the applicable standard of care. I mean, don't we generally try and not get involved in standard of care questions? It seems to be suggesting there that you have the standard of care would require you, instead of duty of competence or whatever. But
Ken, what if it said if consistent with the applicable standard of care? We've already said we're not opining. We've said several times in this opinion we're not opining about standard of care.
If is better. I'm more comfortable with an if there. I'm always reluctant to opine on standard of care questions when in ethics opinions, though.
Well, we're not.
Or should, if consistent. Yeah, I guess it raises questions in my mind, you know, situations where there is a standard of care that would obligate the lawyer. I don't know this field, you know, in terms of, you know, in trust and estates issues. I mean, it seems to me that's suggesting that there are situations where the standard of care, as opposed to your ethical obligations, would require you, I guess, to at least consider involving professionals. Should.
I just interpret it to mean that the lawyer's actions should be consistent with the applicable standard of care. And I think it's relatively benign because I feel like we say many times we're not opining on that. So.
Is that concern limited to the third sentence?
Yes.
Because it seems the primary points we're trying to make are addressed head on in the first two sentences. The third sentence, it's not that it doesn't add anything, but it's more of kind of an add-on. But I think adding if consistent addresses the concern.
Why don't we make the two additions that have been suggested? And then we can get a sense of the group as to whether that, Mimi, are you available for drafting?
Yes, I am. What would you like me to do?
Okay. Amber, what exactly, now I'm not remembering your exact language, but you should as discussed above.
As noted above in footnote 4 or something, I think is what she said, or something.
So if you go right before we in
Amber, is that right?
Above,
we can't hear you.
In footnote 4.
Yeah, sorry, I was talking into the void. Right. I mean, just because we actually, you know, we do repeat the language from footnote 4, so it seems odd not to acknowledge it.
I think that's fine. So let's maybe just make the we lowercase. And then and then in the next change would be in the last sentence. Before the word consistent, put if. Okay.
And then I think, Mimi, could you go back maybe to footnote 4? I think there were maybe some people that weren't quite back in time to see that. If that's correct, they could just look at that quickly. That's the change that we made, as discussed, to sort of address the issues surrounding the question of using judgment in decision. So we weren't going to change the language in the body of the opinion, but we have this footnote. Does anyone have any concerns about footnote 4 and footnote 9? I think those are the two changes, right, Steve?
That's it.
No concern.
I like it.
Okay, good. I see some nodding heads and stuff. So maybe, is there anything else to say on this, Steve?
No, I think with hesitancy, I venture that it might be time for some active member of the committee to make a motion.
I'll make the motion.
I'll second it.
Okay, sorry. Can you tell me who that is? I have it in shared screen mode, so I can't see your face.
Kyla made the motion. I think it's a motion to send it for 60-day public comment.
Okay.
Yes.
And the second,
Was Brandon.
Brandon. Thank you, Brandon.
Sure.
Any further discussion? Otherwise, I'll take the roll call vote. Hearing none. All right. Dina Roche,
Yes.
Ken Bacon,
Yes.
Sarah Bonola,
Yes.
David Carr.
David sent a message that he has to miss the afternoon session, so
Okay.
he won't be joining us.
Justin Fields,
Yes.
Toby Inlander, Adam Koss,
Yes.
Brandon Kruger,
Yes.
Amber Lee,
Yes.
Joel Mark,
Yes.
Kyla Rowe,
Yes.
Hunter Starr.
Yes.
Thank you.
Yay. All right, thanks everybody, and thanks Justin and Steve for working on it over lunch, and for all the subcommittee's hard work on this, and everyone else's in reading it, because it's a lot, but it's really important. I think we all agree. So next we are going to we're gonna take on the opinion lawyers as experts. I know we are gonna get back to new opinions, but with some timing issues, I want to move to that discussion of the lawyers as expert. And I'm gonna let Adam initiate the discussion on that.
Wow. Thanks, Dina. I appreciate it. And thanks for pushing me out of order so I can run after this. Okay, so lawyer as an expert. I took the comments that we had from last time, which were not a ton, and then I tried to draft a digest and at least get a first completed version with a hope of maybe one more edit after this, and then maybe try to get it towards almost done by the time I'm off the committee. Oh, you just went full screen and I lost my version.
Oh.
Don't worry, I can get it back.
Okay.
So, I mean, look, I did some little cleanup and tried to make the issues and digest match together. I tried to shorten it. We've talked a few times about shortening this section A in discussion, but I'm not sure quite what to cut out of it in order to make it shorter. My goal is to try to make this a 7-page opinion rather than 10. So I'm happy to cut things out or even take a scenario out if anybody thinks one is just worthless or not adding enough to the opinion. We got to on line 169, which is page 6. We had some comments about adding shadow traffic and brand and putting some disqualification in. I know I'm trying to keep this towards an ethics opinion. But you know, specifically under this scenario, the first one, I think is generally going to be ethically permitted, but likely lead to disqualification based upon expert rules. So I think it's important to put something in about that, just to make sure that people are aware that shadow traffic is out there. So nobody, oh, well, I'm not breaching any ethics to a client. Well, that's all well and good. But you're likely still going to be disqualified in these situations. And then another disclaimer after. So I hope that has addressed the topic sufficiently. If people think that I should get further into disqualification and the substantive law of expert disqualification, but I think that's probably veering a bit off of our COPRAC functions. Let's see. The third opinion, Dina had some comments about last time about not assuming that the person's going to do something improper, which I think was a good point. And I probably took too far the first time. So I basically just said, look, on the facts that we've got here, and assuming that there's continuing confidentiality, everything is fine. The third scenario, this is the one that probably started this entire opinion. which is the American Airlines case in California versus Commonwealth on the model or on the Illinois rules out of the Northern District of Illinois. I think that, in my opinion, I think it's been sufficiently distinguished from American Airlines to make it so that we can come to the conclusion we do, because American Airlines, remember, is the case that essentially held that the rules of professional conduct or the 1.7, or I guess 3310, was applicable to testifying, but I think the PMK aspect of it, the fact that it's a 30B witness with fiduciary duties, most likely takes it out of that realm. And I think we've gotten to the point where, based on prior discussions, we're fairly in agreement that the expert is not subject to the rules on that basis, although there might be some other, like the 8.4 type of discussion. There's a little dicta in American Airlines. I've sort of dealt with it as best I can by saying it's the prior rule. I don't think there's a better way to deal with it. I think that was unnecessary to the opinion, and frankly is dicta, that American Airlines said it applies for 3310 applied to all types of legal employment as opposed to just being a lawyer. But in any event, 1.7 specifically talks about representation. So I think it's sort of neither here nor there. And then like I think I said last time, the final scenario 4 was added because I wanted to specifically call out 1.7C and the relationship to the rules of professional conduct and how they can apply if it's the same matter. So I am open to sort of comments with the hope of me being able to put this in potentially public comment form by the next meeting.
Adam, I just had a comment on scenario 4, and it might just be, roughly sketched out right now. And if I can pull up my notes.
Sure.
You're referring to rule 1.7C1, and it says informed written consent is required. And I might be mistaken, but I think it's just written disclosure. Is that an informed written consent rule or just written disclosure? This is at rule 2.
You are correct. That was just that's a great point. And thank you, because that would have not been good.
Okay, no worries.
Where are we? Is there something that needs to be edited here?
If you can put a note on scenario 4 on line.
Can't even tell where scenario 4 starts.
I'm in the red line at 299, but I don't think that helps me. But that doesn't help me unless you're in the red line. Okay.
It is 299 in the red line. Written consent is not required. So if you could just put a note in there that that's not the case, I might need to fix that in the prior scenario as well.
Yeah, it should just informed written or written disclosure, I guess. I don't know.
It's written disclosure, not informed written consent. Thank you. I did have a question in there that I was searching for a case, but that's more for me. And I actually didn't realize until I was reviewing this again this morning that I left my own find a case. But I couldn't find something about using, it was further up. Online. Line 290, right above that. So rule 1.9C has the prohibition against use of a client's confidential information. And I think I need to find something that says that you can't use confidential information against a current client as well, because there is no specific prohibition in the rules. Obviously, that would be a breach of fiduciary duty, but there, I think that needs a citation of some sort. So that was a note that I sort of left for myself that got left in.
And could you cite to the State Bar Act BMP code section. Is it 6068E? I think.
I have, is that specifically say use of it against a current client too?
Maybe that's not in use. I haven't.
That was just that 6068E is, correct me if I'm wrong, but that is just defining the confidential.
Might be right.
To maintain the confidences at every peril and preserve secrets. I was looking for something, so 1.9C talks about maintaining secrets, not disclosing confidential information. But then I think it's what C2 talks about not using that confidential information to a client's disadvantage either. So I was looking for a counterpoint to that, because obviously you couldn't do that with a current client either. That's not something I need this second. That's just more me finding that rule.
Adam, I have some questions or comments on section A of the discussion section.
Okay.
So in the first paragraph, you note that the committee is not opining on the practice of law. Excuse me. I assume you mean we're not opining on what constitutes the practice of law. And if that's the case, the rest of that section reads as if we are somewhat opining on the practice of law, because you go through some general conclusions about what would or would not be considered the practice of law. And I wonder, which I found sort of confusing.
I would love to take out the part that says we are not opining on what is and is not the practice of law, and simply say acting as an expert witness is not the practice of law. My understanding is I cannot do that.
Can we just then stick with, for the purpose of this opinion, it is assumed that the exemplar lawyer serving as a testifying expert witness is not engaged in the practice of law?
I thought I did do that somewhere. So yes. Yeah, I mean, look, we could cut out the entire section A.
I think my
77, 78, it says, I think what you're talking about.
Right. I think that it read to me like we made one statement like this, we're going to assume X, and then we sort of, the opinion goes back and retreads some of that particular issue. For example, and also I found certain statements like, moreover, it would not make sense to determine that a lawyer testifying as an expert was engaged in the practice of law. And then the first sentence of the following paragraph, sort of confusing, where you say a lawyer who acts as a consulting expert is often engaged in the practice of law. It just seemed, I mean, we either take it out and say we assume X and then just go from there, or if we're going to have additional sentences about whether something is or is not practice of law with respect to a lawyer testifying or acting as an expert, then I think that we need to be a little bit more precise in our language.
I kind of read that differently. I mean, I thought what we're saying is, well, you might not be practicing law while you're testifying. You also may have an active law practice, which you are practicing law. And if that's not what we're trying to say, then maybe we ought to clarify it. I agree.
Well, I assume that the lawyer who's testifying or working as an expert is a practicing lawyer, when he or she is not acting as an expert.
So the point of these three paragraphs says 7 basically of A, or at least the first few this page, the one we're looking at right now, is to try to call out a distinction between testifying and consulting.
Mm-hmm.
Right? Because I hire, and I know a lot of you have hired lawyers to testify on standard of care or ethics.
Right.
And it is a blurry, it is very easy to cross the line into providing legal advice as opposed to fact expert opinion testimony. And so the point of that was to call out that potential difference. And I mean, look, if I had my way, I would say being an expert is not practicing law, consulting on a case is, but we can't do that. And then the third point is the ABA's opinion essentially stops at this point. So the ABA opinion doesn't do a lot of conflict analysis and really does an analysis of what is a testifying expert, what is a consulting expert, and what is and what are the roles. And I mean, it's more about, is it a law-related service?
Is there a citation for that opinion, by the way? I know it's a non-unanimous.
Cut out in the various, it's ABA. It might have gotten cut out.
Okay.
It might have got, it is ABA 97407.
Okay.
But it may have been pulled out in one of the various rewrites. Good call. I'm happy to try to wordsmith that around, and I get your issue, Amber, and it is a very, I was trying to do the dance and just say it. I mean, look, again, I'm not sure for the opinion we are making. I have considered just cutting that entire section out and essentially saying, look, this opinion is about experts testifying as opinion experts. It is not about somebody consulting, and we aren't dealing with that. And that would shorten it.
Right. And you know, with respect to the ABA opinion, which noted that it's a close call when you're dealing with an expert, a testifying expert, we could say that and say that, you know, the one ABA non-unanimous opinion has stated X. For the purpose of this opinion, we assume Y, you know?
But that was a close call with respect to whether it was a law-related business or not with respect to whether it was practicing law. So that's, I don't think there's a debate over whether or not being an expert is practicing law. It's not. So the discussion about whether we need to get into whether it's a law-related business is, I don't know that we do to that point, Adam.
Yeah.
But I don't know what other people think about that.
That makes sense to me.
If you guys, if the committee is of the opinion that A is not necessary, I'm more than happy to shorten it to a paragraph that says this is what we're doing and this is what we're not, a footnote. I'm more than happy to get rid of that section.
I would be in favor of that.
Yeah, and when you were talking about finding ways to shorten the opinion, I had the same reaction about section A, that this might be a good place where we can cut space on the opinion and cut the page count. So, you know, and I'm happy as kind of with a fresh set of eyes to work with you and go back and forth with some red lines and see what they look like before the next meeting, if that would be helpful.
Okay.
It is important that we have some foundation, some solid foundation for the proposition that that you're not subject to the rules of professional conduct. Otherwise, the opinion has no bite. Exactly. So some version of this has to stay in, it seems to me. And it seems to me important to point out that even if there's some issue as to whether this is a law-related service, that can be overcome with sufficiently clear disclaimers. I would hate to think that I am not on solid ground when as a testifying expert, I disclaim an attorney-client relationship. And I think I also think it's very important to be able to do so. You know, if you're an expert witness, you don't want to be your retention agreement is discoverable, right? Which of course is totally inconsistent with it being an attorney relationship, right? But more than that, you don't want the person who's cross-examining you to be able to suggest that you've assumed a fiduciary duty of loyalty to the person who has asked you to testify. So some significant part of this should stay in my view. Are there other, I don't want to jump in, but I have a few other questions.
Sure.
And I'm going to just pull this thing up. Adam, our first question is at lines 16 to 17.
16?
I think it's 16 to 17,
Okay.
yeah. I wasn't quite sure, maybe I just misread it. But it says here, provided that the lawyer does not use or disclose any information acquired by virtue of the representation, right, other than when the rules otherwise permit or the information has become generally known. And then it goes on and says, nor may such information be disclosed other than when permitted by the rules. Didn't you say that last clause up above when you put disclose in line 13?
Yeah, hold on. You're right. That's super. It should be just at the end of known.
So you want me to delete the rest of the sentence?
I'll reread one point because that's from 1.9. So I will reread that and make sure that it follows the rule 1.9C.
I guess my second question, and I'm not sure I've got this right, but I think it's at 157 to 66. That's what I've written down anyway. And then again, maybe at 192 to 199. It's a question of imputation, right?
You're up a little further, right, Steve? 157.
Hold on one second. Let me just take a look here. Sorry. No, I'm sorry. It's further down. I guess it's the next. It's how about we can drop down to I think it's 192, and I apologize for the confusion.
No, there's two sections on 1.10.
Yeah, well, I guess my real question is, why are these conflicts imputed? If they don't have, why isn't the lawyer, I think you say at one point, well, of course, the lawyers I'm sorry, I can't, I wish I could, I'm gonna have to go, let me go to my copy because I can't really follow what the machine copy very well. Okay, 157. It does not make a difference to the expert's ethical duties. It says here, we believe that the rule acts to impute upon expert the confidential information law firm obtained from company. Yeah. Well, is that really true? What does that mean to impute on the information? What if the lawyer doesn't have any such information?
I agree with you, Steve, and I took a little liberty with 110. A strict constructionist reading of 110 would have it be only a one-way imputation for subsequent representations And in the scenario that this is, which is scenario 1, technically under 110, information would not impute to the expert because the expert is not representing anybody, and therefore 110 doesn't come into play. That is a strict constructionist analysis of the rule, and I have struggled with that and decided to read it more like the left wing of the bench, and apply the spirit of the rule. But I know exactly where you're getting to.
Yeah, because we're writing for disciplinary purposes, right? We wouldn't want this lawyer to be disciplined, would we?
But I do think that if one person, so perhaps the 110 discussion here gets cut out, because I would not be comfortable saying what is highlighted in line 161 to 63, or saying the opposite of that.
It's not imputed.
I do not want to say it doesn't impute. I would like to not say that it does not impute. I can be convinced to say nothing and not address 110, but I don't think I want to specifically say, well, no big deal. If you're an expert, you can go against a former client because you're not representing anybody now. So it doesn't matter if the lawyer down the hall has confidential information, it's not imputing to you. That makes sense?
I guess my instinct is that this is going to get dealt with under disqualification, because under the cases you cite about disqualification, information, whether he promises not to use it or not, right? Whereas if he doesn't have confidential information, I'm comfortable with the idea that he can testify, because it seems weird to have the disciplinary standard be stronger than in some ways to read more strongly than the disqualification standard.
So you would think perhaps putting that down to 170 or so, 177, and the end of the shadow traffic, and say, I mean, I guess it would create then a rebuttable presumption that the expert has gained confidential information from attorneys within the expert's firm?
No, I'm not sure whether that would be right or not. All I'm thinking is that the literal language of the rule doesn't support the result here, and there's no discussion of why the result should be different than the language of the rule. You know, we believe that the rule acts to impute. Well, I think we just agreed that this rule, by its own terms, does not act to impute. So if we're going to have that, we ought to have more analysis and discussion. If we're not going to have it, then I think the answer is he's free to act, but he may, if he doesn't have confidential information, it doesn't have to use confidential information. He's free to act. But he may be disqualified.
Anybody else have any thoughts on 110? I've struggled with this one before, and I know I took a leap on that.
My second question is about 192. I guess is my third question, but it's not clear to me why experts' disqualification should be imputed to the rest of the law firm. Why is an expert's disqualification based on a personal interest of the expert? It seems weird because it seems perfectly clear that if the expert has no involvement in the representation, then this limitation has absolutely no impact on the abilities law firm to represent, the law firm's ability to represent the client. So a relationship that this lawyer has, which arises from not from the practice of why would we, where they're not practicing law, why would we impute that?
I've always thought that the personal interest exception is my wife, my husband, mother, family. I would not consider expert testimony to be a personal interest. That to me is a professional interest. I do not know. I do not have authority to back that up. I frankly didn't even consider the fact that testifying professionally as an expert could be a personal interest. So I don't have authority to back up my position. But I have always taken the personal interest to mean spouse, essentially, or one of the other disclosure obligations under 1.7C2.
Well, I'm not taking a definitive view, right? I just think,
no, I know.
Because I think it says the language in 1.10A1 is the prohibition is based on a personal interest of the prohibited lawyer and does not present a significant risk of materially limiting the representation of the client. Certainly the second part is true, right?
Well, I don't know about that. I mean,
if the lawyer is uninvolved in the representation?
I mean, I don't see how it's any different in that situation than if the lawyer was if it was a representation as opposed to an expert. You still gained confidential attorney-client information as a result of a case. So you were not the lawyer. You were not representing a party as an expert under this scenario, but you have gained, somebody else was, and you are a third party, a necessary third party who has gained confidential information. So you are bound as an agent pursuant to the attorney-client relationship.
Right, but the whole firm is bound in that circumstance because they had an attorney-client relationship, right?
In the first one, yes.
Anyway, I just raised the question. I don't think it's enough to say simply, at least for me, to say that 1.10, the exception to 1.10 doesn't apply without a little more discussion. You know, I just wonder. It seems weird. It seems very weird to disqualify, to say the whole firm has to provide notice. That, you know, this is, think about the logic of this. You could have somebody who was not practicing law, right? When they gave this expert opinion, and they gave it out of the firm's New York office, right? They're in a completely different practice area. And you're saying that the IP lawyers in the New York, in the San Francisco office have to provide informed written consent. What's the point?
Well, so how about Steve, would you be comfortable writing a screening requirement pursuant to comment 2 by saying that the expert is a non-lawyer similar to a paralegal or a secretary and therefore needs to be screened out?
Well, the logic of that is says representation.
If I'm sorry, if I can just, I'm wondering if Oasis West helps us at all or muddies the waters further, right? We have continuing residual duty of loyalty issue that if imputed to the whole firm might prohibit it without us making a definitive determination. I mean, because in Oasis, the attorney in the subsequent matter wasn't even acting as an attorney, right? Wasn't he just gathering signatures or something?
He was out there protesting against the firm's former client's interest.
Right.
I do not remember offhand whether it was his former client or the firm's.
Okay. I'm just wondering if that's.
Let me give you another example, okay? And then reflect on this personal interest thing. What if a person has a mortgage with a bank, right? Or something along those lines that would make it impossible for them to, they'd be terrified to oppose the bank in litigation, right? Because of the consequences for them in terms of their difficulties with the bank in their own personal capacity, right? Would that conflict be imputed to every other member of the law firm if in the event that the law firm someone else in the law firm was asked to sue the bank?
I think the answer to that is no, Steve.
Well, and so then why is this different?
Gaining of confidential information.
Why is that different?
Pursuant to an attorney-client relationship. Maybe not yours.
That prevents that particular lawyer from acting zealously with respect to the bank. Isn't that the relevant consideration? At least I'd like to hear. I just think this is not an adequate analysis of why that's not a good argument. It may not be a winning argument, but I'd like to see more about why it's wrong.
And on the topic of what is a personal interest conflict, our rule doesn't seem to have the same comment, but I was just quickly looking, and the ABA model rule does have a comment addressing personal interest conflicts that we might want to look at or consider more in analyzing the issue Steve raised.
Yeah, and we're kind of running out of time for discussing this issue, which I think is an important one to resolve. So maybe we can give some more thought to that and give Adam feedback. Hopefully, Adam, you're able to meet with your working committee in between drafts and kind of.
I will do that.
Yeah, anyone else that has feedback on this issue or any other issues that they didn't get to share with the group would be helpful. Does anyone have any final comments about this, or is that okay that we leave it here? Adam, do you have any further questions or?
No, I think those were good. The 110 part especially has been something I struggled with, so I will continue working on it and try to pare down
Yeah,
get
and work
something
with your
that's happening.
subcommittee too, and those folks
Yeah.
who can give feedback and fresh eyes or to issues and, you know,
Okay.
on that. I'm trying to figure out a modified schedule here. We have 4 more opinions to discuss and we wanted to talk about new topics. And so, well, we've talked about new topics, but we need to sort of vote on those, which I imagine will maybe take about 15 minutes. But I just wanted to get some feedback on, if anyone has any feedback about whether, I'd like to discuss the client release retention opinion from Amber's, for sure, because I know that that's been off the agenda for a while and it's close. I was going to try to send emails to Ken or Brandon about whether we think that you'd be okay moving your opinion to next time, or whether you want to try to have just shorter discussions, like 15-20 minutes on some of these opinions, just because if you have a question or something you want to ask people about. Otherwise, we can instruct people to, send you a message about, any comments that they have in the meantime. So maybe you guys could give us your feedback on that right now, so we can kind of sort of map out the rest of the afternoon. I also know we had a really short lunch, and so I would like to give people a break if that works too. I don't want to keep you guys slaved to the computer all day. So
I'm fine with, I mean, I don't mind, the flat fee one wasn't quite ready for prime time anyway.
okay.
I'm fine with passing that one. And if anybody has any comments or suggestions, Joel sent me some. I can incorporate those and hopefully get it all ready for next time.
Yeah, I probably only need about 5 minutes because I had a couple questions I just wanted to throw out there and see if there's any feedback on it, but I can.
Okay, that would be great then. Okay, so what we'll do is we'll move Ken's till next time. Thank you, Ken. And then Brandon, we'll plan for a shorter time where you can ask a couple of questions and get feedback from yours. So what I think I'd like to do now, before we get to Amber's and then Sarah's, and I'll try to figure out the break in between there, is I think, Mimi, if we could maybe just go back to those opinions, the new opinions and advisories. Hopefully people had an opportunity to think about those. And we can talk about whether we want 2 or 3. I think naturally we'll probably revisit some opinions again in the fall when we have a different, a different configuration for the committee. So I know this is kind of an interesting time where some people will be terming off shortly, but I do think it's important to still be working on new opinions. And if they had any thought, I had, Sarah messaged me over lunch about the in-house counsel opinion. So I think on that opinion, if everyone agrees that it would be worth exploring something along those lines, I think she and I will confer about that and maybe agree to co-draft and lead on that opinion. And we'll try to come up with, so we're not going to do the whole universe of things, but we'll try to think of some interesting issues and present them to the committee. If you all agree that it's valuable to consider some opinions related that are sort of focused and directed to in-house counsel.
I think it's important. I was looking at the number 7, the in-house attorney-client privilege one, because I think that's an issue that I see pop up, just in my practice and other attorneys who do, in-house risk management for firms.
Yeah, it does come up a lot. I think there's a certain subset of issues that come up with in-house counsel that are unique to in-house counsel that I think would be interesting to explore, so we can talk through those and solicit feedback from people on that if we agree that that's a good topic to pursue collectively. So that can be one, if we agree to that. I want to get everyone's buy-in on this. I know I'm trying to shortcut these conversations because we don't have a lot of time, but what are other opinions that has anyone seen an opinion that they'd like to work on with somebody or consider?
Dina, I've kind of grown a little bit of a backbone, especially after Kyla was pointing out that she's newer. And I feel like with the trial publicity, I do want to tackle it. I'm a little bit nervous because I'm so new, but I'd like to kind of formulate it. And the way I thought about formulating it was in the context of 3.5 and 3.6 together, is there a prescription on trial publicity aimed at a public agency that is intended to influence the jury pool against that agency. And the issues I see in terms of why it may be a problem are the opinion that came up, and it was 1987-95, and then some of the things that have happened more recently in California with regard to some of the statements about this office or that office is unjust, and practices that they may or may not do. And in the last 3 jury trials that I've conducted, we're definitely getting members of the public, even in I'd say it's more recent trend within the last couple of years, who are definitely kind of parroting back these statements that are being made to the public. Hey, I've heard this is a very unfair agency, those kinds of things. And I'm wondering if there's any kind of prescription or what the limitations are on making public statements about essentially a party that's going to be a party to these actions in general, with the intent to influence the jury pool against that party in future actions. The specific is, of course, attacking district attorney's offices, and city attorney's offices. I think that that's where it's most applicable, but I don't see much that has been done on this specific subject. 3.5 is generally about, you usually see it with a prosecutor saying something about a criminal defendant in a way that would influence the jury pool against them. That's kind of the general jury pool influence. Then you've got 3.6, which is specific contact with individual jurors after to influence future behavior. In any case, I'm having some trouble narrowing down the specific question that I want to ask.
Can I jump in for a second?
Yeah, definitely, Justin.
One thing we haven't discussed, but I think is relevant to what Hunter said about kind of diving into this, is that, in the past, when we've discussed potential opinions and people have signed up and said, yeah, I'll look into this, I'll look into that, that doesn't necessarily mean that you are now in a position where you must prepare an ethics opinion that will be published by the state bar. Part of this process is doing further research, coming up with an issues outline. We discuss it and determining whether or not it makes sense to proceed. And so, we haven't really, I think, discussed that sort of interim aspect to this process, which is actually doing further research, narrowing or focusing the issue, determining whether there's something that we think is going to be useful in an ethics opinion. So, I know Andrew isn't here to talk through the specific protocols there, but I think as we're going through this, having in the back of our mind that it probably makes sense to have a number of potential opinions being considered right now, because at the end of the day, we may decide, what, maybe 1 or 2 of these we won't want to proceed on, or maybe, we'll look at the in-house counsel issue and realize, that's two distinct opinions that we might want to develop. So this is kind of an iterative process that we're going through right now. And so I think it's great that you're comfortable taking these initial steps, Hunter, and it's definitely going to be a team effort, but as an initial matter, if you go through this and think, it's just not going to work out, that's a conversation that we will have in a subsequent meeting. But I think as an initial step, doing the research, coming up with an outline, and coming to a conclusion in your own mind, whether it's worth pursuing further once you've taken those initial steps, is all part of this process. So I just want to point that out, that for Hunter and other folks who are new to the process, that you're not jumping all the way into the deep end just yet.
Yeah, we talked a little bit about that before, during the last time, about that step. I agree with that. That's important. So thank you, Hunter, for showing an interest in that, and maybe there's someone else that can even help you with the outline or think about other ways to look at it. I don't know, Mimi, I mean, we don't need to pick a full drafting team for these now, right? I mean, that's not,
No, typically somebody just consider, you know, is assigned to a topic. They see what they can come up in regards to like an issues outline of some sorts, or just a really like their outline to see if there is something there, like there are authorities and cases, and that there's just even just a topic itself.
right.
And then at the next meeting, we talk it out some more. And at some point, people, you know, once it starts getting a little further, you know, they volunteered to join the drafting team once they, you know, we figure out if it's even worth pursuing.
Yeah. All right. So if you're willing to do that, Hunter, I mean, and I think if we all agree to that, I think it's very interesting, certainly something that we don't have an opinion on that topic. And, you know, if you're willing to do that, and maybe if you want to solicit the help of someone else to help you do that as well, and kind of that initial like outline, I think that sounds promising.
That would be great. Yeah.
Yeah. So that sounds interesting. Anyone else? I know, Kyla, did you give any more thought to that, the one below that, or did you want to?
Yeah, I'm happy to do the same with that one below, and just kind of start poking around with the research and maybe figure out, you know, that's a very specific question that they're asking in this blurb here, but figure out if it can be more generally applicable to other attorneys as well. So yeah, I can do that.
Yeah, I think that's a good point. And I think sometimes like we talked about, you start to look into something and maybe it takes you in a slightly different direction that you think might be more meaningful or more applicable. So maybe that, you know, that might happen with that. And I think that's okay too. I don't want you guys to feel like you're on an island too doing this. So definitely reach out to other people. There's a lot of people that, you know, worked on these, and leadership, you can email us, or we can help connect you with somebody that can help even this initial stage and stuff, because, you know, you kind of want to look at it in stages. Otherwise it can feel overwhelming. And, you know, sometimes lead drafters take a very big role in drafting an opinion. Sometimes it's by committee of the subcommittee. I mean, I think that's also something that we need to reinforce and address, where this shouldn't fall on the shoulders of one person who's drafting and then get, you know, feedback or comments from people. It really works best when the opinion itself is, you know, shared with other members of the subcommittee who take hands at drafting and revising the opinion too, because then you have that sort of other second, third, fourth set of eyes, and then people tackle. Sometimes people divide up an opinion and say, here's 3 sections of the opinion, and someone's going to take a different section, you know. And provided that there's some continuity with voice and style like that, also that approach can work really well. So there's not like one way to do it. And it doesn't mean because you know, decided to do this outline that you have to draft the whole opinion, or that you're going to be out there. So definitely, if you flesh this out with other people, and, you know, if people want to volunteer to do that or separately contact you, you can contact them. And then, you know, if we decide as a committee that we want to vote it out for, you know, that we want to further develop the opinion, then you definitely have a subcommittee and a team helping and collaborating with you, because that's what it's supposed to be. So I don't want anyone to feel kind of, but
Just so you know, it doesn't have to be like a full-blown outline right now. It's just trying to narrow the issue. What is the issue? And then even if you want, you can even think of a couple of hypotheticals, potential hypotheticals that could help you, you know, frame up how you're gonna discuss the issue and answer the questions that are being presented. But it doesn't need to be super long. I mean, like one or 2
Yeah, that's a
pages.
great point, Mimi. It doesn't need to be like, you know, sometimes people provide a really detailed outlines, which is great and lengthy, but that does not need to be a 10-page lengthy outline at all. Yeah, I agree with that. Thanks, Mimi, for bringing that up too. Okay, so is there any other, we were talking about, I know Andrew feels strongly, and I agree with him, that it would be great to have an arbitration advisory in consideration to develop. Did the arbitration people have any chance to think about an advisory that they think would be?
No, sorry, I got tied up. I didn't have a chance to just talk to the guys over lunch. I mean, some of them, the questions about updates, I'd have to look at those. In terms of new advisories, the one that was mentioned about mediation confidentiality, how that's handled in a fee arbitration, where there's been a prior mediation that now becomes a subject in the fee arbitration. I'll have to flush that one out. That's something that somebody raised to the State Bar Program staff. I haven't had that, in my experience, come up in an arbitration, so I'm not sure how huge of an issue that is.
Well, do you guys want to, would it make more sense for between meetings to talk, confirm more about it? And then we could put this on the agenda for next meeting too, to just kind of think about an advisory that we want to add, you know, because I don't want to make someone, I mean, it doesn't make sense to just feel like you have to pick a particular topic and then spend energy on something that may not be as worthwhile as something else. Even if it's revisiting one of the opinions, like that may be worthwhile to do given change in law or other circumstances. So maybe that if you guys don't mind, you could talk between meetings and kind of come up with a couple, one topic or something that you want to present to the committee as something worth pursuing.
Yeah, no, that's fine. And when, you know, Andrew mentioned they've got the training coming up next week. I mean, unfortunately, without the committee anymore, that was the sounding ground where advisory issues came in.
Yeah.
I would hope that, you know, now that they're getting back into these online trainings, sometimes that's where these issues pop up as well. So
yeah, that's a good point. Maybe something will
flow for next week, but
What we can do is for the program evaluation survey that, you know, you receive after you know, at the conclusion of the event for the MCLE evaluation, we can add an additional question to it, just saying, you know, do you have any topics, you know, potential, you know, topics that you would like the ethics committee to consider writing an arbitration advisory on?
that's fine, yeah.
And we could see if we get any feedback. I mean, considering
Yeah,
we
that's
have
a good
about
idea.
almost 600 people registered, I'm sure there'll be some topics that people want answered or some questions.
Yeah, it's
Okay.
usually a mix with a lot of existing arbitrators and some people just thinking about it. So, yeah, I think that's good.
Okay, great. Any other, Justin, did you have any comments or?
I was just going to say to Ken on the mediation confidentiality, I've had that come up in my practice outside the context of fee arbitrations. So I know it comes up in the real world, but in terms of fee arbitrations, I think that for me is, I don't know enough about whether this is significant enough of an issue that the powers that be would find it useful and appropriate for us to have a standalone opinion on it. But if we go that route, and if you're able to get any intel on that, I'm happy to be a part of that one and offer my experiences dealing with that issue in non-fee arbitrations.
Yeah, I mean, the only reason I can, you know, I said I'll dig into it with staff. That's where it came from. I mean, if the case and the fees in dispute, you know, involved in part in a mediation that occurred, that would be the only context I could think how it would pop up in a fee arbitration.
Yeah, or statements are made in an arbitration, or excuse me, in a mediation that are relevant to the fee dispute. You know, somebody makes an admission of some kind, and you know, what does that? But it comes up in the context of a mediation. How do you deal with that? But again, I don't know how often that really comes up in fee arbitrations. So I guess that's kind of the threshold question: is how.
Yeah, I'll look into it, and if it looks like it's something that needs addressing, I'd be happy to have you jump in.
I mean, intellectually, it's kind of an interesting question. I just don't know practically whether we need it. So.
Okay.
Okay, so any other comments?
Is that going to be one for consideration then? Should it go on the agenda as well, or are we going to wait until the next meeting to look into it a little bit more?
I think we're going to wait till the next. I think we're going to carry this over. I think we're going to carry this over till the next meeting.
Okay.
Mimi, so I think we've agreed. Unless people, I don't think we need to take a formal voting action on this, right? I think we've agreed that we're going to explore a couple outlines on those topics. That Kyla's going to work on one with, hopefully someone will assist her, and Hunter, and then the in-house counsel. That we're going to try to develop something that the committee might consider is worthy of a formal opinion, and then we'll revisit this next week too, to see if next meeting to see about arbitration advisories. And if someone has some brilliant idea next meeting too, then we could add that too. So if we can add this to the agenda next meeting, that would be great, Amy.
Okay, sounds great.
Okay. Does anyone else have any comments about this? Okay, then why don't we, if you're ready, Amber, why don't we move along to the client file release retention
Sure.
opinion?
So there aren't that many substantive comments other than, and I corrected a couple of typos. So I'll just go through the two main corrections or additions that were made. The footnote number 2, I think it was Ken who noted that the piece could use clarification in terms of why the committee is concluding that the file retention period specified in Penal Code 1054.9 doesn't necessarily control a lawyer's ethical obligations. And the reason that I gave was that it was because that statute dealt specifically with post-conviction discovery rather than lawyers' ethical obligations. So, and Hunter was helpful in identifying In re Steele as a case that kind of makes that point clear. So footnote 2 is intended to address that issue. And I don't know if the committee thinks that is sufficient or it needs further clarification, less, or what? Should I wait for the committee's comments before going on to the next point? Anyone has comments, questions on footnote 2? Okay, guess not. Dina, did you have a question or comment?
No, I had no, go ahead. I think you can go over your topics and then we can talk about it.
Okay, and then the rest of the substantive changes were intended to address the one kind of a big picture issue that several committee members had the last time we discussed this opinion, which is what kind of concrete guidance can we give to lawyers reading this opinion about a file retention agreement? For example, what can we say about the disclosures that have to be made or should be made? What other considerations should we tell the lawyers to consider in drafting a file retention agreement with the client? And I know that Andrew had some concern, and I after having thought about it more, I shared his concern in citing the rule governing or defining informed written consent, because there really isn't a existing authority that would support the committee, concluding that informed written consent is required in the context of file retention agreement, not explicitly. So I tried to walk that line, but I don't know that I've done enough to give the kind of guidance that the committee thought the opinion should give in terms